presiding. All those having business, excuse me, Judge Brian Gramines is presiding today. All those having business before the court draw near and you shall be heard. God bless the state of Ohio and this honorable court. You may be seated.
Good morning. Today's date is July 18th, 2025. It's the morning docket of the Lawrence County Municipal Court. I apologize for the late start. We've had some technical difficulties, which I believe are now resolved. We're going to do things a little bit differently this morning than we normally do. Judge Landefeld, we're going to go ahead and call your cases, and I'm going to step off the bench if you can hear me. Judge Landefeld, can you hear me? I think you may be muted.
Yes, I'm sorry, I had myself muted.
No worries, Judge. We're going to go ahead, since you're here and the attorneys are here on this, and we had a late start with some technical difficulties. We're going to go ahead and call your cases, and I'll step off the bench until you're finished. That way we can go ahead and get you taken care of, and so you can continue on with that.
Very well, thank you.
All right, thank you, Judge.
And good morning. Today is July 18th, 2025. As you heard, this is Lawrence County Municipal Court. I'm Judge David Landefeld, retired judge, sitting by assignment of the Ohio Supreme Court. We're having a pre-trial in basically two cases, I believe, companion cases, the state of Ohio versus Joshua Hamlin, which is CRP 25-147, and Crystal Hamlin, which is CRP 25-148. Mr. Hugh, you're here on behalf of the prosecuting attorney, J. Roger Smith, the second on behalf of Mr. Hamlin. Is that correct?
Yes, Judge.
And and then Warren Morford Jr., you're here on behalf of Crystal Hamlin. Is that correct?
Yes, Your Honor.
Very well. Mr. Hugh, just for the record here, are we in compliance with Marcy's law?
Yes, Your Honor, we are.
All right, so I take it that the complaining witness in this case has been notified and is, if wishing to attend, could attend, if not wishing to attend, does not attend. Is that correct?
That is correct, Your Honor.
All right. So where are we? I know that discovery has been requested, and discovery, I assume, Mr. Hugh, has been provided.
Your Honor, we have provided what we've had available to us up to this point. There is some information, indication that there might have been a witness that we need to locate. We need to try to locate. So we're going to try to do that. And I've made Mr. Smith and Mr. Morford aware of that. So I think we've agreed that we would have one more pre-trial before we ask for a trial date to be set. That's correct, Judge.
All right, and I noticed there is a protection order that has been issued in each of these cases. I assume there haven't been any issues with respect to that. Is that correct?
We have not heard of any issues, Your Honor.
Well, how much time are we talking about before we need to have another pre-trial?
I would defer to the state judge as far as how long it would take to locate that witness. They've been identified in discovery with just initials, so I assume the sheriff would have that information relatively soon.
I think maybe what we need to do is ask the sheriff to ask the victim who that person would be, because I think the victim is the person who identified the witness. Just came to us in a report just with the initials. So we're going to follow up on that.
Well, I have to be there in Lawrence County in person, I believe on July the 29th. Does that give you enough time to get that, or would we need to schedule this later?
I am not available on the 29th, Judge. I've got a trial that Tuesday.
Okay. Well, going into August, is there, I mean, we can do this by Zoom if you wish, the next pretrial,
The judge,
but what's a good day the week of August 4th for you?
actually, Monday the 4th is a good date, or August 8th, that either Monday or Friday that week. I don't know, Mr. Morford. Is that?
I'm good either date, Your Honor.
Okay, well, I have to be in Benton County on the 4th, so why don't we make it the 8th
That's fine.
of August? And we'll make this another Zoom hearing. Is that acceptable for parties here?
It is on behalf of
Yes,
Mr.
Your Honor.
Hamlin, Judge, yes.
I'm sorry?
Yes, Judge, on behalf of Mr. Hamlin, that's acceptable.
On behalf of Mrs. Hamlin, acceptable, Judge.
And we're okay with it.
All right. Is technical for the court, I guess I need what's convenient for the court. And I see you've got a packed court room this morning, and I don't particularly want to interfere with any of the other proceedings that might happen
Okay.
on that date.
I think the 8th would be fine, Your Honor. We can accommodate it.
And you want to do that at 10 o'clock?
Yes, Your Honor.
Yeah.
Okay, we'll set both these cases, then for August the 8th at 10 a.m., we'll do that via Zoom. And if there's anything else we need to do, please just I'll review it, and I'll be happy to put on whatever injury we need to put on. So, is there anything further that I can do here this morning?
Not from Mrs. Hamlin's standpoint, Your Honor.
Nor on Mr. Hamlin's standpoint, Judge, thank you.
Okay. And Mr. Neal, I was here the same. Okay.
Yep.
Well, thank you all for
Thank you, Judge.
participating, and we'll see you on the 8th.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you, Judge.
I'll call you.
State of Ohio versus Raymond W. Meredith, case number CRB 25167. This is Mr. Ashworth, the special prosecutor.
Mr. Ashworth, can you hear us?
Yes, sir, I can. Can the court hear me?
Absolutely. This is case number CRB 25167, State of Ohio versus Raymond W. Meredith. Mr. Stratton is here. Looks like.
Yeah, I was just recently given this case, Your Honor.
I'll let Mr. Ashworth know. I'm resigning from this case. Sean Stratton will be taking over, so that's who you'll be dealing with. So I filed a motion to withdraw, and I believe I entered, or orders already been entered. I don't know where Mr. Meredith is, why he's not here today. But I've given the whole file over to Mr. Stratton, so with that.
This will be Mr. Stratton's case going forward. Mr. Ashworth and Ryan Ashworth has been appointed special prosecutor in this matter. Mr. Stratton is here, and Mr. Tyler Smith, former counsel, is here. However, Mr. Meredith is not here this morning. I don't know if that changes anything for the parties today. And just, Mr. Ashworth, just so you're aware, Mr. Tyler Smith has taken a new job, and so he will not be able to handle any more cases, and so the court is somewhat inclined to give some leeway on the handoff of the cases and some of the notice on some of this stuff. But I don't know if that has any change, how the parties think about this.
I've told Mr. Stratton that there was, I believe, a while ago, I filed just a general motion for discovery,
Mr. Ashworth was asking for more specific what we're looking for. I told Mr. Stratton, I've given him the file, he's going to go through and make a more specific demand. If that's okay with you, Mr. Ashworth?
That's fine, no, that, I'll get ready to back up the whole thing, and I'll be happy to do so. If that's what Mr. Stratton would want, I think you probably have it all. I'll have the objection, you step down. Good luck and congratulations, I guess.
Yeah, I'll get in touch with you privately and we can talk.
Very good.
Thanks, Tom.
All right.
All right, so I'll go to you, Mr. Stratton, first, since you're just coming on the case.
Your Honor, I asked that he's not here today. I don't know where he's at, so I haven't had any communication with him. This is from just recent, so.
Have you had any communications with Mr. Meredith, or did you have a good
Not-
phone number for him?
That's one of them that I was hoping you'd be here today. The only thing I have is his address.
Okay.
So it's on the complaint.
Oh, okay.
Mr. Ashworth, I'll go to you. Would you have any problem, because it's a little bit of an unusual situation with the handoff, would you have a problem with doing a brief continuance for a couple of weeks, that way that Mr. Stratton can at least send out a letter informing him to be here prior to the potential warrant being issued?
No objection.
Okay.
Your Honor, that's fine. Mr. Smith gave me the file. It appears there's no phone number in there. If Mr. Ashcroft has a phone number for him and his discovery, maybe he could provide that to me.
Okay, and I think Mr. Smith indicated that there's an address, and so you can always send a letter.
Yeah, I'll do that.
That way we've at least covered the bases with that, so. I'll start with you, Mr. Stratton, because I knew you had some trials scheduled, I believe, early in August. How's the 8th look for you?
The what? I'm sorry?
The 8th?
The 8th will work, Your Honor.
Okay. Mr. Ashworth, how's the 8th look for you?
That'll work, Your Honor.
All right, I'll continue this till August 8th for pretrial at 10 a.m. And then we'll see if Mr. Meredith shows at that point, and we'll take the case up further at that time.
All right, thank you, Your Honor.
Very good, thank you, sir.
Thank you. Mr. Ashworth, do you have any other cases here today?
I have one more, Your Honor. It's Tisha Kessinger Mullins, which Mulford's the defense counsel, and we can spin through it quickly if you like.
Mr. Ashworth, do you have a case number on that?
Sure, I can find one for you.
I think we've got it.
State of Ohio versus Teresa Kessinger Mullins, case number CRB 18318.
This is CRB 18318, State of Ohio versus Teresa Kessinger Mullins. Mr. Ashworth is present on behalf of the state. Mr. Morford is present on behalf of Ms. Mullins. Mr. Ashworth, Mr. Morford reached out to me this morning to see if his client would need to appear here today, and it was indicated that my understanding was you guys had an agreement to dismiss this matter.
It's great, Your Honor. This is an old matter. It was actually handled by an earlier special prosecutor. It was filed back in 2018. I got it recently. After discussion with Mr. Morford, I think it's appropriate to dismiss this without assessment of cost.
Mr. Morford, I presume there's no objection.
None, Your Honor. Thank you, Mr. Ashworth.
This matter will be dismissed at state's request without cost.
Thank you, Your Honor.
Thank you. Mr. Ashworth, always a pleasure.
That's all I have. Thank you, Your Honor. I appreciate it.
Thank you. Let's go ahead. We have Mr. Tyler Smith in the courtroom.
State of Ohio versus James DeMint, case case number CRA 24-290, CRB 24-635, CRA 24-786, CRB 24-787, A and B.
I was just talking to him out in the hallway. I don't know where Mr. Stratton is, I believe that.
Case now.
All right, we got Mr. Stratton in the courtroom. So the state of Ohio, James Burnett, CRA 24-240, CRB 24-675, CRA 24-786, CRB 24-787,
Just, you can give it to them.
CRB 23-1859. We're calling this a little out of order. Mr. Smith, I don't know if you heard Mr. Burnett, but Mr. Smith has taken a new position, and he has to withdraw my line for all these cases. He had to withdraw from all the cases. You have been reassigned a new appointed attorney, Mr. Stratton.
Yes, sir.
I don't know if you've had an opportunity to meet with him at this point or not, but we'll go ahead and handle this portion of the matter.
Your Honor, I believe that hometown, Mr. Stratton has the new letter, but I believe that there was something about work, is that correct?
No, I've been going to work.
Okay,
It was a home pass that they called about
okay.
like 3 weeks ago, and they needed the judge's approval, but they couldn't answer for the judge. And I guess you're the judge that put me in hometown, so I was wanting to go like overnight pass on Saturday night. That's part of my program, but they had no way of getting approval from the judge over the phone.
Well, what say you as his provider?
Okay, so I reached out to the other court liaison to see about what was going on, and she said that since he's not on a monitor or anything, that the way that they earn passes is they have to earn them just like every other client, you know, good behavior, things like that. So I'm not sure who the house monitor reached out to about the passes, but I mean, I don't think there was a problem with it.
There wasn't.
It's okay with the judge, and so.
Well,
She's double checking to make sure that, so I didn't expect him to be called this soon, so.
I typically take the position, Mr. DeMint, that if I'm not going to get involved in your treatment from the perspective of if they think it's appropriate and you're not on a lockdown monitor, then it's fine.
My house monitor needed something in writing that it was okay, that not that you're approving it, but that there's nothing against it.
Well, I think that you should be able to tell them that if the judge is okay with it.
Because I've been waiting a month.
Yeah, I typically I'm not going to take a position on it. If they believe that it's okay and appropriate, then I have no problem with it.
Yes, sir.
You've been compliant, and you're doing good in your treatment. Now, if you want to monitor and there was some concern there, that would be a different story.
Right.
They would need approval.
I was just covering.
But with this, as far as I'm concerned, if your treatment provider's fine with it, I have no problem with it. If they are not fine with it,
Yeah.
I'm not fine with it.
Right.
Okay?
All right, and then she can tell them.
Okay.
All right, good.
All right, Mr. Stratton.
Your Honor, we just need to continue on, maybe set this out sometime in August. So they don't need anything in writing. Just,
Okay.
Yeah.
How's your calendar, August 29th?
August 29th to work, Your Honor.
Be a pre-trial preliminary at 10 a.m.
Thank you, Your Honor.
Thank you, Mr. Burnett.
Thank
Keep up the good work.
Thank you.
August 29th.
State of Ohio versus James Bassett, case number CRA 25 and A&B.
All right, this is State of Ohio versus James Bassett, Sierra 2525 A&B. This was originally Mr. Tyler Smith's case as well. Attorney New Steyer has now been appointed on the matter. And Tyler Smith has been submitted for withdrawal. But we want to go ahead and call the case in case you haven't had time to speak with your new attorney and let you know who they are and the like in case we need to recall that. State's represented by Attorney Philip Hoover.
We've got a report today as well, Your Honor.
And I've advised Mr. Badgett of the situation that I'm taking a new job and I won't be able to represent him anymore, and that I advised him that Mr. Seiler was appointed to him, and he's in good hands. So.
You can read my handwriting.
That's a good report, Mr. Badgett.
So we need to find a date to come back on this one, I would assume.
August 29th, work okay, Mr. Steyer?
It does.
Well, we set this for preliminary hearing, August 29th, 10 a.m.
Thank you.
Thank you.
State of Ohio versus Jonathan Gibson.
Look at the file.
Case number CRA 2597, CRA 2598.
The State of Ohio versus Jonathan Gibson, CRA 2597, CRA 2598. This was former Mr. Tyler Smith's case. It has now been reassigned to Mr. Roger Smith. Mr. Gibson is present. Step for a preliminary hearing, what we're calling a little early in the docket.
May I ask for a chance?
Still true. No, you do well, right? Yeah.
Mr. Gibson's a very good report.
I've advised Mr. Gibson as well that I'm having to step down, that my grandfather will take over.
Holy cow.
You know you're recording this, right? That just went out on the internet.
Everybody spit their phone.
Sorry, that was a brother, then a father, now he's a grandfather.
All right. Mr. Roger Smith, August 29th works for you as well.
When we get out of July, that would help. Actually, I've got a Thursday, Friday trial. I'm here the 25th of August, if that's an option.
We do the 25th.
Okay.
To August 25th for preliminary hearing, 10 a.m.
Thank you, Your Honor.
Thank you, Judge.
Thank you. You're doing your best. All right. Now we're going to move into back to the regular docket. We're going to start with reviews. When you hear your name called, come down to the table on my left, your right, and wait for your name to be called.
Review hearing, anyone have review hearing?
Alexis Anderson, Jonathan Benson, Dennis Cook, Andrew Curry, Alicia Fell, Mike Ferris, Automec Gomez.
All right, Alexis Anderson?
Yes.
This is State of Ohio, this is Alexis A. Anderson, 1605 Beach. All right, Ms. Anderson, looks like we got in 12 hours of community service since the last hearing. We still have 24 left, and we still have a case balance of $10,125. So I see you've been making payments on that, so we'll set you a new review hearing.
Okay.
Since you're making good progress, I'm going to go out a little bit further. Are Mondays or Fridays better for you?
Either one.
Let's go to September 29th at 9 a.m. for review.
Awesome. Thank you so much.
Thank you. Jonathan Benson?
Yes.
All right, this is State of Ohio versus Jonathan Benson, PRC 24-1988, A, B, and C. We have a report.
No, he has completed us.
Okay, well, that's fantastic news.
Thanks, sir.
Looks like if that was all you had left on the case, so this matter is now completed.
All right. Thanks, sir.
Congratulations, you've done very well, and we're proud of you leading the program. You now relieved of all of the duties, at least for this case. I don't know if you have any other cases, but at least as far as this case goes, this case is now closed, and, you know, we can come back to court for it.
All right, thanks, sir.
Thank you.
Appreciate it.
Dennis Cook?
No.
Dennis Cook?
I'm on Zoom, sir.
All right, it's the State of Ohio versus Dennis Cook, hearing 2603, hearing 164177, POC 143645, EBC, POC 143122, A and B. Mr. Cook is present via Zoom. In the matter.
Yes, sir.
All right. Mr. Cook, where are you zooming in from?
Scholar.
You're at the Stark Community Justice Program? All right.
Yes, sir.
Since you're there, there's not a whole lot you can really do on the cases at this point. So we're going to set you a new review. Get any idea when how long have you been at Star?
It's May 28th, sir.
Okay. Any idea the approximate time of completion?
Not right off, hang on just a second here, Ms. Green. At least another 90 days.
Okay. Well, why don't we do this? I don't want to lose track of you, so we'll do a halfway mark. I'm going to set you another review. You can appear via Zoom for September 29th.
September 29th?
Yep, and that'll be a review at 9 a.m. on all cases.
No. All right, thanks, sir.
All right, thank you.
Have a good day.
You too. Andrew Curry? Andrew Curry. All right, this is State of Ohio versus Andrew Curry, CRA 23464 A, B, and C. CRB 23463, CRB 22351, CRB 23291, CRB 2361, 320, 2695. Time is now 10:41 a.m. And Mr. Curry has failed to appear. There'll be a bench warrant to issue immediately for failure to appear. Alicia Fell. The State of Ohio versus Alicia Fell, TRD 202695. This matter was set for 9 a.m. Time is now 10:42 a.m. Ms. Fell has failed to appear for the hearing, so there'll be a bench warrant to issue immediately. Mike Ferris, just hitting home runs here. State of Ohio versus Mike Ferris, CRB 25247. Time is now 10:42 a.m. Mr. Ferris has failed to appear. Be a bench warrant to issue. Please. Sir, what's your name?
I go by Cody, but it's Guatemala.
Okay.
Yeah.
Mr. Gomez?
Yeah.
This is State of Ohio versus Guatemala Gomez, 24-416. All right. Good report. You've completed the program there. I'm glad that you're continuing on with aftercare. You have $225 that you owe on this case.
I have money today that I was going to pay on it.
Are you going to pay all of it today, or just a portion of it?
Just a portion of it.
Okay. I'll note that you're going to make a payment today, and we'll set you a new review hearing.
Okay.
You can also work off, I believe it's $50 a day. You can work that off on community service if you want to save yourself some money as well.
Okay.
So, we're going to set you a new review for September 29th at 9 a.m. If you have all that paid off by then, or you've worked it off by through community service and probation has cleared it, you don't need to appear in case it be closed. If you don't, you gotta be back.
Right.
And as you hear, if you don't show up, you get a run.
Yeah.
All right, we'll see you back on September 29th.
All right, thank you, Your Honor.
Thank you.
Heather Humphrey, Misty Hunt, Jeremy Kearns, Denise Sexton, Jared Stover, William Rice, Misty Shaver, Tony Walker.
Heather Humphrey,
Hello, Your Honor.
good morning. The State of Ohio versus Heather Humphrey, PSC 24-1981. Ms. Humphrey is present here this morning. Looks like you still owe 24 hours of community service and $543 on your fines. Do you have a
Yes.
payment today?
I have like $7, yes, Your Honor.
Okay. I know that you're going to make a payment on this. This is a 24 case. So you need to start working off getting rid of your community service. So.
Yes. Can I explain? Due to my situation, still living out of my car with the heat and stuff, I'm having to use more gas and stuff, like to charge my phone and keep the air on. So it is harder to get over here now because I stay closer to my work, which I'm only making $150 a week. So it has been difficult, but
Sure.
yeah, I do.
If you speak with probation, they may be able to set you up somewhere close to where you're at,
Okay.
so that you can do community service right where you're at. And then,
Okay.
Which, I know community service may not always be pleasant, but.
No, I want to get it done because Judge Capper said that I could work off my fines as well, and which is I'm grateful for that as well.
And, you know, it's hot outside and the like, and I'm sure it's hotter and a lot worse if you're sitting in your car.
Yeah.
So it's probably, this is one of the instances where no matter what you're doing for community service, it's probably better than just sitting. So
Yeah.
if you'll speak with them, I'm sure they can maybe help you be able to find somewhere.
Okay. I appreciate that, Your Honor.
No problem. I'm going to set you back for September 29th for 9 a.m.
The 29th at 9 a.m.
Yes, ma'am.
Thank you, Your Honor. You have a great day.
Thank you, too. Misty Hunt. It's the State of Ohio versus PSC 21-2088 AT&C and CRB 21577. Ms. Hunt is present. All right, Ms. Hunt, that's a good report. You're down to 9 hours of community service left and $325. So your sobriety is the most important thing right now, but if you can get out and do some community service, that'll only help speed your case along.
I've had some health issues for this past month. Has been really bad. I've ended up having walking pneumonia and stuff, but I plan on getting it completed and done here within the next couple of weeks.
As someone who's had that, make sure you get that taken care of. That
Yeah.
stuff can kill you.
Yeah.
So, I'm gonna set you back for review September 29th. Good report, keep doing what you're doing.
Thank you.
Jeremy Kearns. This is State of Ohio versus Jeremy J. Kearns, CR 23738, CR 23739. Mr. Kearns is present. Received a good report here this morning. And looks like you're just down to completion of your treatment and 12 hours of community service. You're moving in the right direction. You're almost there.
Thank you.
I'm going to set you back same day, September 29th.
Thank you, Your Honor.
At 9 a.m. Thank you. Denise Sexton. So the State of Ohio versus Denise Sexton, CRB 24538. Sexton's present, receive the report. overall, it's a good report. They'd like to be able to, they want to see you in the office for screenings.
Yeah, I just been able to start walking again.
Okay.
Somewhat.
So they've indicated that's going to be a future requirement. So
That's
we're
fine.
going to have to comply with that.
Yes.
I was just able to get her transportation needs met too, so.
Okay. All right, still got community service. I understand there's been some
Yeah.
hurts on, you've been injured, I'm not particularly concerned.
And I got a payment on my fines today.
I'll move that payment as well. I'm going to set your review for September 26th at 9 a.m. Jared Stover. Jared Stover. It's the State of Ohio versus Jared Stover, CRB 24-461. Mr. Stover is not present. He has not been seen in treatment. And has no call and no show for several appointments, so it would be a failure to appear. They want to issue immediately. William Rice. The State of Ohio versus William Rice, TRD 20-2404, TRD 18-2548, time is now 10:50 a.m. Mr. Rice has failed to appear. There'll be a bench warrant issued. Misty Shaver. State of Ohio versus Misty Shaver, TRC 17-3465, ABCDE. Shaver is present here today, and this is a 2017 case, and I don't have that you've ever done anything on it.
I went through, I put myself through OVP, a 28-day program. I have completion certification here, and I have signed up for services through Lodestar Behavioral Health Services. I will sign a release today, so they can start giving you the drug screens. Judge Capper wanted me to do drug screens through services. That's what he wanted me to do. I have a job, and I'm going to start paying on my fines. I do my community service.
And then just start working community service. If you've got a job, what are your days off?
It doesn't matter. I can do it start on Saturday, this Saturday.
Well, I'm going to put you on a much shorter leash because we don't have evidence that anything's been done. And so I'm going to put you on for another review August 1st at 9 a.m. And I'm going to make a note that you're going to begin community service on July 19th.
What time? 10 a.m.?
7:30 a.m.
On the first, what time?
Oh, 9 a.m. All right. Thank you, Ms. Shaver. We'll see you back on August 1st.
Thank you.
Tony Walters. The State of Ohio versus Tony Walters, CRA 24-466, CRA 24-467, A and B. Mr. Walters has not appeared. It's 10:52 a.m. Cited to be here at 9 a.m. So the failure to appear, bench warrant to issue. We're ready for a rain shower. Next group of cases we're going to call are arraignments. These are first appearances on your case. When you hear your name called, come down to the table on your right. We're going to go through the charge of charges with you at that time. You have, as you likely heard earlier on the video that you received, you can enter one of three charges: guilty, not guilty, or no contest. If you enter a guilty plea, you're making an admission that you committed the act or acts that are charged against you. If you enter a not guilty plea, you are denying that you've committed the acts at this time. And if you enter a no contest plea, you're not admitting that you committed the violation, but you're also not contesting that either. If you're unsure of what you should do, you should enter a not guilty plea or reserve all your rights before the court. You also have the following rights before the court as well. We are recording everything in here, so you have the right to remain silent. If you say it, it's going to be recorded, it's going to be on the record, and if it's against your interest in saying that, if you think you need to tell me something and it's not in your best interest to do so, if you tell me it's being recorded, the state of Ohio can use that against you in further proceedings. You have the right to have counsel in this matter. If you can't afford to hire your own counsel, counsel can be appointed to you if you qualify. You have the right to have reasonable bond set in this matter to secure your appearance. And you have the right to force the state of Ohio to prove each and every element of the offense charged beyond a reasonable doubt. You would call first case.
State of Ohio versus James Roy Lee Murdoch, case number CRB 25353, A, B, and C.
All right, this is State of Ohio versus James Ray Lee Murdoch, CRB 25353, A, B, and C. James Murdoch. All right, time is now 10:55 a.m. Mr. Murdoch was decided to be here at 9 a.m. He has failed to appear. There will be a bench warrant to issue.
State of Ohio versus Ian Brown, case number CRB 25350.
All right, this is State of Ohio versus Ian Brown, CRB 25350. Mr. Brown is present this morning and handed a copy of his charges.
Emily.
All right, Mr. Brown, it's alleged that on or about April 26, 2025, you did knowingly by any means cause there to be a substantial risk of physical harm, miscellaneous property, the property of Renee Hay, without her consent. That's an alleged violation of Ohio Revised Code, Section 2909.06A1, criminal damaging. That is a misdemeanor of the second degree. Misdemeanors of the second degree carry a maximum penalty of up to 90 days in jail and up to a $500 fine. How do you wish to plead?
No contest.
All right, so you're not admitting that you committed this act, but you're not contesting it either. All right, so I will accept your no contest plea in this matter. And I'm going to enter a guilty finding on your behalf.
So, Your Honor, this young lady, is it Hay? Is that true? Ms. Hay is the victim in this matter, and I've just asked her about the issue of restitution, and I haven't gotten an answer from her yet. I don't know if she has a figure for it right now. Do you know how much the phone is worth?
Like 200.
So she estimates $200 if Mr. Brown would accept that figure, then we'd ask for that as restitution in this matter.
Okay. Mr. Brown, did you understand what Mr. Hill has indicated here?
Yes, sir.
Okay. Is that the number that you believe the property would be worth? Otherwise, you're entitled to have a hearing, and you're entitled to have them demonstrate what it is worth. Now, it may be worth more, which is possible. It may not be worth the $200. I don't know. But you have the right, if you don't want to come back for a further hearing on it. If you believe 200 is appropriate, you can stipulate to that.
That's fine.
Okay, so you want to stipulate that $200 is appropriate?
Yes,
sir. Mr. Gill, do you have a sentencing recommendation?
I'm sorry, Your Honor.
Do you have a sentencing recommendation?
We would recommend a 10-day suspended jail sentence. We'd like an order, we'd like to have Mr. Brown placed on probation for a period, and we're not necessarily asking for reporting unless the court, of course, he has to pay the restitution, so I guess that's important to have him be able to report periodically. We would like an order through his probation that he stay away from this young lady and make that a term of his probation.
Mr. Brown, anything else you want to say on your own behalf?
No, sir.
All right. I'm going to accept the recommendation of the state in this matter. I believe it to be appropriate. I'm going to order you, I'm I'm going to order 10 days in the Lawrence County Jail. I'm going to suspend all 10 of them. It'll be 2 years of probation. It'll be $200 restitution to be payable to Renee Hay.
Emily Hay. I think we may have gotten the name wrong on that.
Okay, to Emily Hay. Yes, and Mr. Brown, that's going to be paid through the court. So when you make the payments, you need to make the payments to the clerk, whether it's one payment or several payments, make them to the clerk at that point, and I'll do a no contact order as a term and condition of your probation. That you can't have any contact either directly or indirectly with Miss Emily Hay. Do you understand that?
Yes, sir.
All right, that includes any type of social media posts or any type of messaging app or anything like that. Do you understand?
Yes, sir.
All right.
Let's go in this case now.
It's H-A-Y. Is it Emily, E-M-I-L-Y?
Yes, Your Honor.
Yeah, it's H-A-Y-A. All right, that'll be the court's order. Mr. Brown, before you leave, you're going to need to meet with probation before you leave.
Okay.
All right, thank you.
State of Ohio versus Felicia Hannon, case number CRB 25437. And State of Ohio versus Thomas Hannon, case number CRB 25438.
Your Honor, if I may, on the summons, it says Felicia Dix.
I'll look everywhere for a list of sentences.
Well, it's now Hannon and the former Mrs. Dix is now here today as well. So we've got State of Ohio versus Felicia Hannon, CRB 25437, and State of Ohio versus Thomas Hannon, CRB 25438. Well, let's start with Ms. Hannon first, even though it appears it looks like it's a cross filing. All right, Ms. Hannon, it's alleged that on or about July 18, 2025, you've been knowingly cause or attempt to cause physical harm to Thomas Hannon, family or household member. That's an alleged violation of Ohio Revised Code 2919.25A, domestic violence. Domestic violence is a misdemeanor of the first degree. It carries a maximum penalty of up to 180 days in jail and up to $1,000 fine. How do you wish to plead?
Not guilty.
I accept your not guilty plea. Do you wish to be considered for appointed counsel?
Yes.
All right. Are you working presently?
What is it?
Are you working presently?
Nope.
Not employed at all? Okay. I will appoint attorney Luke Steyer to represent you. I'll continue the bond that you've already posted in this matter. Mr. Field, I don't know if you've had, it's a cross filing. Was there any request for any type of protection order on either side?
Well, I think we would like to inquire of each of them whether they would.
Before we go any further with that, I mean, could the court inquire whether there's going to be an appointed attorney for
Sure.
the other defendant? Because if there's going to be another attorney, well, we probably ought to have that conversation amongst us.
I'll go ahead then, before we go any further, I'll go ahead and do the arraignment. This is Thomas Hannon, CRB 25438. Mr. Hannon, it's alleged that on or about July 18, 2025, you were known cause or attempt to cause physical harm to Felicia Hannon, family or household member. That's an alleged violation of Ohio Revised Code 2919.25A. Domestic violence, it's a misdemeanor of the first degree. Maximum penalty on that is up to 180 days in jail and up to $1,000 fine. How do you wish to plea?
Not guilty.
All right, I'll accept your not guilty plea as well. Do you wish to be considered for appointed counsel?
I won't qualify.
Okay. So you're going to hire your own counsel?
Yes.
All right. I will continue your bond as well as you've posted. I think at this point, it would be okay if the state wished to inquire now at this point of Mr. Hannon as to whether or not, well, I'll just ask both of you, so it's easier. You guys want protection against each other?
On Ms. Hannon's behalf, no.
Okay, Mr. Hannon? All right, Mr. Hannon does not wish, so there'll be no protection orders issued either way. Mr. Hammond, how long do you think we would need to hire your own counsel?
Week.
All right, I'll give you a little more than that. That way maybe we can have a meaningful pre-trial when we come back. Mr. Steyer, how does August 15th look for you?
Take a look at my calendar, Your Honor. I'm available.
All right, Mr. Hannon, how's August 15th look?
I think I work.
Okay.
Or 15th, anything after the 16th would be fine.
Okay. Mr. Steyer, you available the 22nd?
Of August?
Yes.
I'm not. I have a jury trial that day.
29th?
I am available that day.
Okay. 29th, work, Mr. Hannon?
That'd be fine.
All right, that'll give you plenty of time to hire an attorney. Hopefully, he can, really, whomever you hire can go ahead and get discovery filed, and then we can come back on the 29th for the pre-trial that night. Be at 10 a.m., both cases, I'll keep them together.
If I may, Your Honor, the summons appears to name my client as Dickus, and the complaint names her as Hannon. I'm not sure what the actual style of the case is.
It's Hannon, I believe, before you came.
On the computer, it's Dickus, so I don't know which would be correct.
My legal name's Hannah.
Okay. Her legal name's Hannon, so we would join the state if they made a motion to amend the style of the case.
The actual charge itself says Hannon on it.
If there needs to be an amendment to Hannon anywhere, we would make that motion.
And we would join in it.
All right. If anywhere in there it's listed, Hannon is listed as Dickus, her formal name, it would be amended to Hannon at this time. So, pre-trials on both, 10 a.m. August 29th.
Thank you.
Thank you.
Your Honor, that's all the arrangements we have right now. We're ready to start pre-trial proceedings.
If you have a pre-trial, can you come in the courtroom?
State of Ohio versus Zachary King, case number CRA 25-363, CRB 25-364.
So the State of Ohio versus Zachary King, CRA 25-363, CRB 25-364. Excuse me, Mr. King's present with his attorney, Mr. DeLauder. The state is represented by Attorney Philip Field. This matter set as a preliminary hearing and a pre-trial.
Your Honor, I believe there's an agreement with the state in this case to dismiss the temporary restraining order that was previously issued. I think there's also an agreement to continue the case for a period of time, allow Mr. King to do a few things, and then if there aren't any further problems, I think the state's willing to nolly the case. The things Mr. King was required to do were, one, complete an anger management course, which he's already completed at this point, and also some counseling related to other issues. He's already well into that process, so he's making good progress. I asked Mr. Heel just now if we could come back in about 60 days instead of 90. I think he's discussing that currently. 60 days, is that okay, given his progress?
Yes, Your Honor, we got some information today and that Mr. King is taking part in some counseling at an agency that I've never heard of before, but looks very reputable based on the information we've received. We want him to follow through with that. I believe that is it Kaner?
Yes.
She doesn't want to have a protection order.
Right.
I don't know if there's one presently or not. I think there is. So she wants that dismissed. She wants us to dismiss the charge today, but we're not ready to do that. Based on the seriousness of the allegations and the information that we've received through law enforcement, we feel like the correct course here is for Mr. King to continue in his treatment. It's my understanding that he did complete an anger management counseling class already, which is a good step. And we're willing to come back in a couple months if they're willing to waive time.
We are.
Look at a dismissal, get another report from the counselor.
All right.
September 22nd, okay with the court?
September 22nd is fine. Be a pretrial and preliminary hearing. Ms. Painter, I'll speak directly to you. Is it your desire to have the temporary protection order dismissed in this matter?
Yes, Your Honor.
Was there any promises, threats, or anything made for you to make you do that?
No.
Okay, I'll find that at the victim's request, the temporary protection order is now no longer necessary, it'll be dismissed. And I'll find that the defendant has knowingly and voluntarily waived time in this matter to allow the case to remain here. And we'll set that back September 22nd for a pretrial preliminary hearing at 10 a.m.
Yes, and I don't know if I said this for the record, but the state's proposal in the case was a dismissal with payment of court costs, which I advise my client.
That's correct. We want to have a good report and no other problems. Condition.
Mr. King, I haven't seen a report on this yet, so you'll need to come back on the 22nd to have a report that day for the court on your progress in your treatment, and it will probably be beneficial to completion certificate from the Arraignment court at that time.
And Your Honor, if you'd like, I've shared the update reports with Mr. Heald. I can make a copy and submit them to the court for the court's file. Thank you, Your Honor.
Let us know if you have any problems.
Yeah, call it, darling. It was the same time. Okay, thank you.
State of Ohio versus Christopher Kramer, case number TRC 25721, A and B.
State of Ohio versus Christopher Bramer, PRC 25-7, B. Mr. Bramer, the president, Mr. Smith, matter set for pretrial.
Okay. I'll have to just...
PRC 25-721, A and B.
Judge, Mr. Hill and I have been working on this case for some time now. I think we have what's going to be a resolution, but I do need a couple weeks. Part of that agreement was to be that my client would get an assessment done. You said you do that?
I still have to purchase my own private insurance. I'm about to get married too.
Okay. He's sometimes happens in these cases, you're penalized if you have private insurance. He has private insurance, so I don't know if we want to do an assessment before he leaves today and come back. I'm good really anytime in August except the 18th.
How about August 15th?
That's the date I'm here, Judge.
At defendant's request, this matter will be continued for pre-trial, August 15th, 10 a.m.
Thank you, Your Honor.
Thank you.
State of Ohio versus John Guido, case number TRC 25944, A, B, and C.
The State of Ohio versus John Guido, PRC 25944, A, B, and C. This is Mr. Rogerson's case, and it's pre-trial.
Yes, I got some message with you Tuesday.
I've been going, yeah, that's the problem. Judge, this is a case that there is a restitution component. The state's going to follow up and get that number. I don't want to enter into a plea and then have to come back for restitution here, and we'll waive time. If we could use that 15th date, or we could pick another date.
All right, defendant's request, this matter will be set for August 15th for pre-trial, 10 a.m.
On Monday. And then we'll get you in to talk about, Josh, what's going on with this case.
State of Ohio versus Andy Long, case number TRC 251051, CRB 25306.
The State of Ohio versus Candy Long, PRC 25-1051, and CRB 25-386. Mr. Roger Smith's case set for pretrial.
Now, she could do the school, she could do the school in 3 days. Okay, we can do it off on that. Approach, Your Honor.
You may.
I can't get my computer on. It's kicking me off the internet every 2 seconds. I can't get on there for nothing. See it, they'll let me in there. So I can messes.
How far out?
It might let me in there. Oh, finally. No, it's a mess.
Yeah, that is a good date.
After a brief conference at the bench, I believe the defendant's requesting a brief continuance in the matter to August 22nd at 10 a.m. for another pretrial. There's going to be some things that the state still needs to proceed in this matter to be able to proceed from the victim. And there's going to be some things that Ms. Long is likely going to need to do to facilitate resolution. So we'll set this back for August 22nd at 10 a.m.
Thank you, Judge. We're working towards a resolution. I'd like her to go ahead and get an assessment. She has an Ohio medical card. If somebody would be able to assess her.
Jesse at hometown back there, raise your hand. So if you'll meet with her, that'll be one of the things that the attorneys indicated may help facilitate resolution of this matter. So if you'll meet with her today, after that, you're free to go. We'll see you back August 22nd.
Okay, thank you.
Yes. This is 25th. Yes, this is Friday.
State of Ohio versus Robert L. Slaughter, case number CRB 24692 A and B, CRB 24346 A and
So the state of Ohio, Mr. Robert Slaughter, CRB 24692 A and B, CRB 24346 A and B. Mr. Smith's case, pretrial.
Yes.
Judge, he has been to Mahaj, and he's got a letter, actually dated yesterday, that he has completed their course of treatment for anger management. He's also got a case that I do not represent him on, Mr. Steyer does, it's set for August 1st.
Yes.
I think the consensus is for judicial efficiency, let's all meet on August 1st, and hopefully this case will be resolved because he has provided proof that he did what he was supposed to do. If it's not too crowded on August 1st, we bump it till then.
I think we'll just squeeze it in that day. So at defendant's request, this matter will be reset. We're going to keep on another case for August 1st.
August 1st.
For pretrial at 10 a.m.
Okay. See you August 1st.
State of Ohio versus Joshua Williamson, case number TRC 21-1959 A and B.
State of Ohio versus Joshua Williamson, CRA 21513, PRC 21-1959 A and B.
Yeah, I got
Mr. Smith's case.
Oh, yeah. Judge, this is a case that Judge Capper's been monitoring for a while. He is receiving treatment from the VA. Amanda Raven just sent me a text. He's compliant. He's doing everything he's supposed to. We've been at this quite a bit. I would ask to come back another 4 to 6 weeks and see where he is. And he always gets compliant reports. He's doing what he's supposed to, but she just didn't have a written report to provide.
August 29th.
Let's see. That's good. Write that down, August 29th. And let Amanda know. That's your next coming.
Defendant's request, matter will be continued to August 29th, 10 a.m.
29th. See you then. Thanks, sir. All right, you too, Josh. See you.
State of Ohio versus David W. Moore, case number TRC 25-135 A and B. Your Honor, this is originally set for trial, but Mr. Smith asked for it to be called.
All right, the State of Ohio versus David W. Moore, PRC 25-135 A and B. Mr. Smith's case, it's set as a trial, but my understanding is the parties have come to at least some form of resolution where there's not going to be a trial.
Judge, well, it's, we anticipate there will be. I have received another video, which is Highway Patrolman, as a deputy video. I just received that from the state, so neither the state nor myself we can go forward today with the trial. Given there is another flash drive video I need to look at, I'd like to set just another pre-trial instead of a trial, because once I look at it, it may change things, it might not. But if we could do a pre-trial instead of a trial, that would, I think, be beneficial. Any day but the 18th in August, I'm good.
Do August 29th.
I can do that.
For a pre-trial 10 a.m.
August 29th. And I'll get you.
It's going to be based upon new discovery that is available.
August
29th. Go for a pre-trial.
August 20th.
29.
29th.
Yeah, 29.
State of Ohio versus Bruce Curry, case number CRB 25-124.
The State of Ohio versus Bruce Curry, CRB 25-124. And it's the Stratton's case and set as a pre-trial.
Yeah, that's awesome. Yes, sir. Put that down fast, that's a lot of money in that. Oh, yeah, yep, that's what I'm shooting for. Did you get from the letter? Okay, all right. I figured you did. I'm not even gonna ask. He's doing great. Going to school for welding. I noted that. very big accomplishment on his part, so we just need to continue and just monitor his progress, Your Honor.
All right. Mr. Can, what say you? Good report, good? All right.
THC level, and we want that to go down before we drop his levels, we put that in the letter. Besides that, yeah, he's being compliant.
All right. All right, Mr. Stratton, how far out do you want to go?
Probably a month, Your Honor, I would say.
August 22nd? Does August 22nd work for you?
Yeah, that'll work.
All right. Defendant's request, matter will be continued to August 22nd for pretrial. Okay.
Thank you, Your Honor.
Thank you.
State of Ohio versus Michael Tilley Jr., case number CRB 24437.
The State of Ohio versus Michael Tilley Jr.
You should have a
Mr. Stratton's case set for a pretrial.
You should have a report there, Your Honor.
I've got one from June 16th.
Should be a new one.
Is it from Sam?
Yeah.
We don't have any new one, that's just out there in the...
I just got a text saying it went through, right before I walked up here.
Let's recall this just in a few minutes.
Okay.
I'm sorry.
Yep. Yeah.
State of Ohio versus Katie Whitley, case number CRB 22767, CRB 22456.
All right, this is State of Ohio versus Katie Whitley, CRB 22767, CRB 22456. Mr. Stratton's case is set for pretrial.
Tammy Whitley is Rhonda Thomas. She here?
Randy, Rhonda Thomas, somebody called.
Oh, who's the other?
She still wants to pursue hers.
Who's the other? Same thing.
No, Rhonda Thomas.
It's easier on that side, huh?
The other one is someone who does.
Okay. All right, so you're Tammy.
Yes.
Okay. And then I have, who's the victim on the assault?
It's Toman.
Rhonda Thomas. Okay.
She called us a weekend.
Okay.
She's wants to monitor the counseling and stuff.
Okay. So, what's your connection? Okay.
She's on the unauthorized use.
Yeah, she used your car.
Yeah. And she doesn't want to pursue hers. She's been bringing her to court and stuff.
Well, the house, what is she doing?
She's been here for 2 years. I didn't know that she had been doing it. They did it with the council.
Well, I was in 22.
Oh, so she.
All right, so Your Honor, these are 3-year-old cases, and things changed during that period of time. And Ms. Whitley's here, she's Katie Whitley's mother, and she said they long ago settled their differences. There was a time in which we were concerned about Katie Whitley's well-being as far as the need for treatment, and apparently she has completed that at some time in the past.
Yes.
The other victim on the assault was Rhonda Toman, and she's contacted us and indicated that she is satisfied and does not want to pursue the charges. So I think at this point, we've reached a point which we will just ask to dismiss the charges.
All right, Mr. Stratton, I presume there's no objection.
Oh, there's no.
All right, both matters that can be nominated at state's request.
State of Ohio recalls Michael Tilley Jr.
State of Ohio versus Michael Tilley Jr. on recall. Mr. Tilley did receive the report, and it is a very good report.
Thank you. Yes.
better than the last time.
It is better. The last letter was very vague. So we'll just continue on, Your Honor, and...
Let's do August 22nd.
Yeah, August 22nd.
Pretrial 10 a.m.
Good job.
State of Ohio versus Tracy Dillon, case number CRA 24575, CRB 24576, CRC 24882.
This is State of Ohio versus Tracy Dillon, CRA 24575, CRB 24576, CRC 24882, and B. This is Mr. Steyer's case.
Were you on till?
This is the way it is for like 4 hours from here. I can't keep up.
I can't even. I'm on the notes. Do you know what day we came back on till?
August 22nd.
Here's Tracy. Here it is.
May I approach?
You may.
Oh, I'll approach as well.
Yeah, come on.
All right. Bill, do you have a motion on behalf of the state?
Your Honor, I think that the goal with respect to the charge in 24 CRA 575 was to make sure that Ms. Dillon was appropriately seeking and staying with the treatment that we wanted her to do. We got an indication today that she is, so we're okay to go ahead and nollie that charge today, and hopefully she doesn't find herself back in here again. We don't want her to be in here.
They're dismissing that. I used to have to deal with stuff.
The CRB 24576 is that.
You will have to come back for that down the road.
Okay. And Mr. Okay. Mr. Gill, there's the CRB 24576 case as well. It's possession or removing the nollie as well.
Yes, Your Honor.
Okay. Both of those charges will be nollied at state's request.
I don't know that he's going to do that.
That leaves the TRC 24882 A and B case, which is a post-conviction matter.
Your Honor, she's scheduled for the OVI school on the 18th of September, so I would ask that we go at least about a week or two after that, if we could.
I'll return her to the review docket on that matter. Let's do September 29th. For review of my meeting.
Here at 9 a.m.
Thank you. Thank you, Your Honor.
All right, thank you.
Your Honor, we're ready to go to Lawrence County Jail.
Yes.
State of Ohio versus Diane Bailey at the Lawrence County Jail. And Ashley Donna is on deck.
All right, this is State of Ohio versus Diane Bailey, CRB 25433. Ms. Bailey is president of the Lawrence County Jail. Ms. Bailey, can you hear me? All right, I'm going to go through some rights with you. I'm going to go through your charge in this matter. You have the option, you can enter one of 3 pleas to this. You can enter a plea of guilty, which means you're admitting that you committed the act. Can you hear me okay? I see you kind of... Okay. You can enter a plea of guilty, which means you're admitting that you committed the act that's the basis of this charge. You can enter a not guilty plea, which means you're denying that you committed this violation. And you can also enter what's called a no contest plea, which means you're not admitting that you committed the violation, but you're also not contesting the facts surrounding the violation. And if you believe that, or if I believe that there's enough evidence, I can find you guilty. Now, you have the following rights before the court. You have the right to remain silent. We are recording this today, and so if you say something to me that is against your interest, Mr. Heald from the state of Ohio is the prosecutor sitting in the courtroom. He can hear it, and he could then use that against you later. So you have the right to remain silent. You have the right to counsel. If you can't afford counsel, we can appoint counsel to represent you. You have the right to have reasonable bail, and you have the right to force the state to prove each and every element of the offense charged beyond a reasonable doubt. Do you feel like you understand my explanation of your rights? Okay. Ms. Bailey, it's alleged that on or about July 16th in Fayette Township, you did with purpose to deprive Walmart, the owner of property or services, knowingly obtain or exert control over said property or services. And it's alleged that it's merchandise totaling $115.94 without the consent of the owner or person authorized to give consent. That's considered theft under Ohio Revised Code 2913.02A1. That is a misdemeanor of the first degree. Maximum penalty for misdemeanors of the first degree is up to 180 days in jail and up to a $1,000 fine. How do you wish to plead? You want to enter a guilty plea, so you're making a complete admission that you committed the allegations contained herein, right? All right. I will accept your guilty plea, and I'm going to enter a guilty finding. Prior to sentencing you on this, ma'am, I want to have someone at the jail give you a urine screen. Okay, so we're going to recall this matter here shortly after you've been screened, and then we'll take up the matter of sentencing at that time. Okay.
What about the prescription that I have?
Well, you can let them know what you have, and we'll take that out once you've been screened. And so, how many days have you spent in jail?
3.
Okay. All right, we'll have you back out once you've been screened.
State of Ohio versus Ashley Donoff, case number CRA 23745, CRB 23746. And Jason Harrell is on deck.
All right. So State of Ohio versus Ashley Donoff, CRB 23946, CRA 23745. This is Mr. Steyer's case. We have Mr. Steyer in the courtroom.
Is it somebody that's in the jail?
It is.
Who is it again?
Ashley Donoff.
Oh, I wasn't aware.
It appears that there were looks like on 4/30 of 2025, there was a bench warrant issued for, looks like leaving treatment, and then there's an arraignment today on that. Ms. Donoff, can you hear us?
Yes, sir.
All right. Mr. Steyer, do you want to speak with her before we?
Well, I think before we get to that point, let me speak to the state briefly and see if.
Sure.
Yes.
Ms. Donna, if your attorney is speaking with the representative from the state of Ohio right now.
May the 12th of this year. She has a more theft in possession. Yeah. So, do you want to let that kind of treatment? Probably, but I mean, once you talk to, are you talking to her? I haven't really where she is. Once you talk to her and see where she.
I'll give her a call and we'll ask to have this case recalled.
All right. Ms. Donna, if your attorney is going to give you a call to jail, and then we're going to recall the case to decide what way to go from here.
I would ask that if a jailer's listening, you hold her out. I'll step out and call immediately.
Thank you.
All right.
Thank you.
Mine will be recalled.
State of Ohio versus Jason Harrell, case number CRA 25-427, CRB 25-428, A and B, CRB 25-429, A, B, and C. And Ivy James is on deck.
All right, Mr. Harrell, can you hear us?
Yes, good morning, Your Honor.
Good morning. This is State of Ohio versus Jason Harrell, CRA 25-427, CRB 25-428, A and B, CRB 25-429, A, B, and C. Mr. Harrell is present at the Lawrence County Jail. He's appearing via Zoom today. Mr. Harrell, I want to go through some things. One of these cases is a felony, but you have the right for the court to remain silent. We're recording everything here today, and Mr. Heald, the prosecutor for the state of Ohio, is sitting in the courtroom. So if you decide you want to tell me something that is not beneficial to your case or is against your interest, it's being recorded. Mr. Heald is going to hear it, and he can use it against you. Do you feel like you understand that?
Yeah, I really do.
Okay. You have the right to have counsel in this matter. If you can't afford counsel, I can appoint counsel to represent you. You have the right to reasonable bail, and you have the right to force the state of Ohio to prove each and every element of each offense charged beyond a reasonable doubt. Do you feel like you understand those elements?
Yes.
All right, I'm going to go through the charges with you. First is CRA 25-427. Mr. Harrell, it's alleged that on or about July 14th in Perry Township, you did unlawfully and knowingly obtain, possess, or use a controlled substance or controlled substance analog, and the drug involved in the violation is a compound, controlled substance, or controlled substance, violation is a compound, mixture, preparation, or substance included in Schedule 1 or 2. 2-wit methamphetamine, a Schedule 1 drug, and the amount of the drug equals less than bulk amount. That's an alleged violation of Ohio Revised Code 2925.11A, 2925.11C1A of the Ohio Revised Code. Aggravated possession of drugs, that's a felony in the 5th degree. Felonies in the 5th degree carry a maximum penalty of up to 1 year of incarceration in either the local jail or state prison, and up to a $2,500 fine. On CRB 25-429A, it's alleged that on or about July 14th in Fayette Township, you did with purpose to deprive Walmart, the owner of property or services. You did knowingly obtain or exert control over said property or services, 2-wit miscellaneous items. It's alleged that that's a violation of Ohio Revised Code 2913.02A1, theft. That's a misdemeanor in the 1st degree. Maximum penalty is up to 180 days in the Lawrence County Jail and up to a $1,000 fine. On CRB 25-429B, it's alleged that on or about July 14th, 2025, you did in Fayette Township, you did with the purpose to deprive Lowe's The owner of property or services did knowingly obtain or exert control over said property or services, to wit, a table saw. That's an alleged violation of Ohio Revised Code 2913.02A1, theft. That's a misdemeanor of the first degree. Maximum penalty is up to 180 days in Lawrence County Jail and up to $1,000 fine. On case number CRB 25429C, it's alleged that on or about July 14th in Fayette Township, you did knowingly use or possess with purpose to use any drug paraphernalia that is equipped for ingesting, inhaling, or otherwise introducing into the human body a controlled substance. That's an alleged violation of Ohio Revised Code 292514C1. That is illegal use for possession of drug paraphernalia. That is a misdemeanor of fourth degree. Maximum penalty is up to 30 days in jail and up to a $250 fine. In case number CRB 25428A, it's alleged that on or about July 11th, 2025, you did in Fayette Township, you did with purpose to deprive Lowe's, the owner of property or services, did knowingly obtain or exert control over said property or services, to wit, a Craftsman inverter. That's an alleged violation of Ohio Revised Code 2913.02A1, theft. It's a misdemeanor of the first degree. Maximum penalty is up to 180 days in jail and up to $1,000 fine. In case number CRB 25428B, it's alleged that on or about July 11th, 2025, in Fayette Township, you did with purpose to deprive Lowe's, the owner of property or services, did knowingly obtain or exert control over said property or services, to wit, a Craftsman inverter. It's an alleged violation of Ohio Revised Code 2913.02A1, theft. It's a misdemeanor of the first degree. Maximum penalty is up to 180 days in jail and up to $1,000 fine. Mr. Bryant, did you understand the charges that you're charged with?
Yes.
Do you have money to hire counsel?
No, I do not.
Are you working currently?
No, I'm not. I'm currently just trying to get my life together, man. I want to go to some kind of treatment program, really. Spending the hours, something really is what I want to do.
Okay. Well, before we get into that, the court is inclined to work with you on that. I'm going to appoint Attorney Roger Smith to represent you in this matter. And if we can have Roger Smith in the courtroom. You are, hang tight. I've appointed an attorney to represent you in this matter. I've appointed Attorney Roger Smith to represent you. Mr. Smith, I'm not going to set bond at this point. We're going to recall this. There are a multitude of cases. Mr. Harrell has indicated that he would like to seek treatment in this matter. Well, there's a felony 5 and then several theft charges of drug paraphernalia. So if you would like, we could go ahead, now that you're appointed, if you would like to either call and speak with him or go ahead and have him assessed, either one.
Since he's interested, it says maybe go ahead and have him assessed, and then I will, after I hear the report from the assessment, I will call him and we'll get him back on.
All right, he's in Portsmouth.
Listen, I want to do this spending now. I want to do spending now.
Well, they're going to do an assessment.
We're going to do an assessment on you now, and then we're going to call.
I've already been assessed to spending now, and
I don't know who they are, and I don't know. One, I don't know that program. They're not typically a program.
Because I'm looking through the foundation. They're posted on Facebook so bad.
So, is there anybody in the back that wants to go ahead and do an assessment here? Okay. All right. So we're going to have you assessed. We're going to call down to the jail, do an assessment on you, and then we'll recall the case, and we'll see about getting you released to treatment today.
So, I did not catch his name. What's his name?
It is Jason Harrell.
Jason.
Mr.
Can I borrow, thank you.
Yeah, you can have, I'll go ahead and give you the file, and then you can bring it back to us when you're ready to have a recall.
You know, man, I come back and see you, I come back and see you to see the whole other person to me. I'm not sure, I've been here 12 days, so see.
Okay, well, we're going to see you here in a few minutes, so,
We'll call you back up, so somebody will call down and talk to you.
okay? So we're going to have you back out here in just a few minutes.
Be unsure who's supposed to call to assess it.
Mr. Gardner. Yeah. All right, we're going to have you back out here shortly.
State of Ohio versus Ivy James, case number CRB 25-125, and Andrew Jones is on deck. Excuse me, that's Andrea Jones.
We have Mr. Stratton still here?
He's here.
Okay. This is State of Ohio versus Ivy James, CRB 25-125. Ms. James, can you hear me?
Yeah, I can hear you.
All right. All right.
Who is this?
Mr. Stratton, this is Ivy James. She's in the Lawrence County Jail.
Okay.
It looks like it was arranged on or about
I'm looking at it.
April 25th that she didn't appear for her trial and left treatment. There was a bench warrant issued a week later, and she has apparently been picked up and was arrested, and we're here for the arraignment on that today.
Yes, she was at amended reads. They informed the court on the 25th that she left treatment on the 17th.
Okay.
I didn't pick up on the name from the jail list, or I would have.
All right, Ms. James, do you admit or deny that you missed your hearing and that you left treatment?
Amended Reads had sent me to another place to transfer me to Liberty. It's a place called United Liberty. But yes, I do admit leaving United Liberty.
Okay.
Okay. I didn't have notes to that effect, Your Honor, but she's meaning to leave it anyway, so.
I believe that's probably not a family, but.
I do apologize.
That's okay.
It's an assault charge, Your Honor.
Yeah, it was United Family.
This is an assault charge that happened at the treatment facility at OVP. And we were prepared for trial. I don't know whether she didn't show up for trial.
She did not.
So, we had people subpoenaed that day. I'd like to know how many days she's been in jail now.
All right, Ms. James, how many days have you been in jail?
6.
6 days?
Yeah.
Why don't we have Ms. James screened today and see where we go from there? Mr. Stratton, any objection to that?
No objection.
So,
In the jail, she was booked on the 16th, so she's only been in jail 3 days.
Okay.
and Your Honor, our position will be that if she's not willing to go ahead and admit guilt on this charge, and then we set her up to go back to treatment, then we're going to ask for a bond, and we'll ask to have it set for trial in a week or 2.
Sure. Understood.
Did you hear?
Ms. James, did you hear that?
Yeah, so I have to admit guilt in order to receive treatment again, basically.
Well, you don't have that, you have the right, if you wish to have a trial, you can have a trial. The state's going to, if you want to do that, the state is going to ask for a bond. Now, whether you can make the bond would be whether or not you can make the bond once it's set. I'm inclined, at least at this point, to screen you. If we have you screened today, is there going to be anything that comes back in your urine? And how honest you are with me right now is probably going to depend a lot on how this goes.
I don't think so. I don't think there's going to be anything in there.
All right. Well, we'll have her screened, and then we'll recall this case a little later in the docket.
All right.
Thank you.
State of Ohio versus Andrea Jones, case number CRB 25439. And Matthew Starcher is on deck. Matthew Starcher next, Pat.
Ms. Jones, can you hear me?
Yes.
All right. Ms. Jones, we're going to go through your charge here. Have you received a copy of that?
I don't think so.
Okay. Could the jailer hand her a copy of the charge? It's faxed down there at 11:14 a.m.
I mean, they not gave me nothing, just, it's fine, just go ahead.
All right, I'll find that. You want to go ahead, that's fine. So, all right, Ms. Jones, we're going to go through your charge here, and I'll inform you of the potential penalties involved in it. You can enter pleas of either guilty, not guilty, or no contest. You enter a guilty plea, it means you're making a complete admission that you committed the offense charged. You enter a not guilty plea, it means at this time you're indicating that you have not committed that offense as charged. And you can also enter no contest plea, which means you are not admitting that you committed it, however, you're not contesting the facts surrounding it, and then if I think the state would have enough evidence, I can enter a guilty finding.
Okay.
You have the right to remain silent. We're recording this, and if you say something against your interest, it can be used against you by the state of Ohio. You have the right to counsel. You have the right to have counsel appointed if you can't afford counsel, and if you qualify. You have the right to bail, and you have the right to force the state to prove each and every element of the offense charged beyond a reasonable doubt. Do you feel like you understand my explanation?
Yes.
All right. Ms. Jones, it's alleged on or about July 17th in Union Township, you did knowingly use or possess with purpose to use drug paraphernalia, two glass pipes with residue. That's an alleged violation of Ohio Revised Code Section 2925-14C1. Possession of drug paraphernalia, that's a misdemeanor of the fourth degree. Misdemeanors of the fourth degree carry a maximum penalty of up to 30 days in jail and up to a $250 fine. How do you wish to plea?
No contest.
All right. So you're not admitting that you committed that violation. However, you're not contesting the facts surrounding that, correct?
Yes, sir. Yes, sir.
All right. I will accept your no contest plea, and based upon the affidavit, I'm going to do a guilty finding. Mr. Field, any input on this?
My understanding, Your Honor, that there was a warrant out in the mayor's court, and that is the reason, I think, why she remains incarcerated. We are not opposed to the court giving her credit for the time. Apparently, she's been in jail about a day, suspending some time in addition as her penalty.
You may want to have her assessed for some treatment. She's got some drug paraphernalia. Is there anybody that would like to assess Ms. Jones? All right, I saw Jessie raise her hand first from hometown. Ms. Jones, we're going to have you back out a little later in the docket. Hometown Recovery is going to call you, and they're going to do an assessment, and then we're going to determine what your sentence will be at that point.
Okay.
So we'll have you out here later in the docket.
Okay.
State of Ohio versus Matthew Paul Starcher, case number CRA 25434, CRB 25435, A and B. And Tessa Stakely is on deck.
Starcher, can you hear me?
Yes, sir.
All right. Mr. Starcher, we're going to go through your charges here today. One of them is a felony. You have the right to remain silent. We're recording everything, and the state of Ohio's representative is here in the courtroom. So if you decide you want to tell me something that is against your interest, it's being recorded, he can use that against you. Do you understand?
Yes, sir.
All right. You have the right to have counsel. If you can't afford counsel, I can appoint counsel to represent you at no cost. You have the right to have reasonable bail set in this matter, and you also have the right to force the state to prove the charge or charges by each element beyond a reasonable doubt. You feel like you understand my explanation?
I believe so.
All right, we're going to start with case number CRA 25-434. Mr. Starcher, it's alleged on or about July 17, 2025, in Roan Township, you did knowingly cause or attempt to cause physical harm to another or another's unborn by means of deadly weapon or dangerous ordinance to Matthew Todd Starcher. It's an alleged violation of Ohio Revised Code 2903.11A2, felonious assault. That is a felony of the second degree. Felonies of the second degree carry a penalty in Ohio of between 2, 3, 4, 5, 6, 7, or 8 years in prison, with a possible additional tail on that of up to 3 additional years on that, and up to I believe, a $10,000 fine. On CRB 25-435A, it's alleged that on or about July 17, 2025 in Roan Township, that you did knowingly cause or attempt to cause physical harm to Matthew Todd Starcher, a family or household member. That's an alleged violation of the Ohio Revised Code 2919.25A, domestic violence. That's a misdemeanor in the first degree. Maximum penalty for that is up to 180 days in the Lawrence County Jail and up to a $1,000 fine. You're also charged with CRB 25-435B. It's alleged on or about July 17, 2025 in Roan Township, you did while under the influence of alcohol or abuse, carry or use a firearm or dangerous ordinance in violation of Ohio Revised Code 23-15A. That's using weapons while intoxicated. That's also a misdemeanor in the first degree. Maximum penalty is up to 180 days in the Lawrence County Jail and up to $1,000 fine. You have money to hire an attorney yourself.
Just don't give me the other one, because I did do 3 on
I'm sorry, what was that last time?
Do you have money to hire an attorney?
No, I don't believe so.
Are you presently working?
Am I currently working?
Yes.
Yes, sir.
All right. Are you paid hourly?
Yes, sir.
How much you paid per hour?
Right now, I believe it's a little over 19 an hour. It's for the union. I make a scale of some sort. I don't know how it works exactly, but.
Okay. Are you getting 40 hours a week?
Yes, sir. Actually, more.
Okay. Do you have any dependents?
No, sir.
All right. How long have you been in jail?
In where? This jail?
Yes.
It would have been early Thursday morning through now.
Okay. Do you think you've lost your job over this?
It's possible.
All right. Well, based upon that, I'm going to find that you may not have qualified before this, but based on you likely losing your job, I'm going to go ahead and appoint counsel. And if you end up making, whenever we set the bond, if you end up making bond, and ultimately you did not lose your job, it'll be reassessed at that time. So I'm going to appoint Attorney Warren Morford to represent you. Excuse me, I'll appoint Attorney Luke Steyer to represent you. Mr. Steyer, Matthew Starcher, there is a F2 felonious assault and 2 M1s of domestic violence and a weapons while intoxicated. We'll start with the state. Is there a recommendation on bond at this time?
State would request a $50,000 cash assurance bond.
All right. I'm going to set bond for now at $50,000 cash of surety. And I presume Mr. Steyer, you're going to want to speak with him.
Well, before we get to that point, I heard you ask how long you've been in custody. I'm going to ask that myself. I didn't catch the answer.
It was the 17th. He's into his second.
I'm not available. I'm available Monday and I'm available Friday. I'm sorry, Monday of next week and the 28th. I'm not available the 25th. So in order to get this done in 10 days, if the state's looking for a bond that he's not likely to make, we're going to have to set this preliminary for Monday. For Monday the 21st, that is.
Okay. Well, we can add it on.
Because I can't be here the 25th. I have a jury trial.
I'll set the preliminary hearing for July 21st at 10 a.m. on this matter. I'm going to set bond presently at $50,000 cash surety. Mr. Sauer, if you want to approach and get the file, and if you wish to have that recalled, you can recall it at any point during the docket. Mr. Starcher, I've appointed you an attorney. He's going to be calling down to the jail to speak with you. I've set your bond at $50,000 cash surety, but after you speak with your attorney, he may or may not wish to have this recalled for a bond hearing for a possible modification. So if he has it, once it recalled, we'll have you back out. If not, I've set a preliminary hearing on your matter for Monday at 10 a.m.
Thank you.
All right, thank you.
State of Ohio versus Tessa Stately, case number
Mr. Steyer, can you
CRA.
approach real quick? This one you see it on there.
State of Ohio versus Tessa Stately, case number CRA 25-425, CRB 25-426, and Stacy Tackett is on deck.
All right, this is State of Ohio versus Tessa Stately, CRA 25-425, CRB 25-426. Ms. Stately, can you hear me?
Yeah.
All right. Ms. Stately, we're going to go through your charges, one of which is a felony in this matter. I'm going to go through your rights before the court. You have the right to remain silent. We're recording everything here. The prosecutor's in the courtroom, so if you decide you want to tell me something that is against your interest, it is being recorded, and the state of Ohio can use that against you. Do you understand?
Yeah.
You have the right to have counsel for this matter. If you can't afford counsel, I can appoint counsel to you at no cost. You have the right to have bail in this matter, and you also have the right to force the state to prove each and every element of the offense charged beyond a reasonable doubt. You feel like you understand my explanation of your rights?
Yeah.
Okay. First case is CRA 25-425. Ms. Stately, it's alleged on or about July 14th, 2025 in Perry Township, you did knowingly obtain, possess, or use a controlled substance or controlled substance analog. Drug involved in the violation is a compound, mixture, preparation, or substance included in Schedule 1 or Schedule 2, 2-wit methamphetamine, and the amount of drug equals less than the bulk amount. That's an alleged violation of Ohio Revised Code 292511A, 292511C1A of the Ohio Revised Code, aggravated possession of drugs, felony in the 5th degree. Felonies in the 5th degree carry up to a maximum of 1 year of incarceration, either in local incarceration or prison, and up to a $2,500 fine. In case number CRB 25-426, it's alleged on or about July 14th, 2025, you did in Fayette Township, you did with purpose to deprive Walmart, the owner of property or services, did knowingly obtain or exert control over said property or services, 2-wit miscellaneous items. That's an alleged violation of Ohio Revised Code 291302A1, theft. That is a misdemeanor in the 1st degree, Maximum penalty is up to 180 days in the Lawrence County Jail and up to $1,000 fine. Do you have money to hire an attorney?
No.
Are you presently working?
What is it?
Are you presently working?
No.
All right, I'm going to appoint Attorney Warren Morford to represent you. He's not here. Is Attorney Stratton here? All right, I'm going to appoint Attorney Sean Stratton to represent you in this matter.
What's the highest level felony here, Your Honor?
And this is a felony of 5th degree.
Huh?
It's a felony of 5th degree.
5th degree, okay.
All right, Mr. Heald?
The state would not be opposed to an OR bond if Ms. Stakely were willing to be assessed for treatment and be released to a treatment provider.
Okay. Mr. Stratton, I know you've not spoken with her, but...
I think that she will do whatever the court says to get out of jail. She'll be amenable to treatment, correct, ma'am?
Yes.
All right. Is there a provider that would wish to assess Ms. Stakely? All right. You're going to we're going to have you back out here shortly. You're going to receive a call from Bethesda, and they're going to assess you for treatment.
Can I ask a question real quick?
And that's up to you. You've been advised that if you say something that is against your interest, then it can be used against you, but ultimately, if you want to ask, and we can go from there.
I was just wondering, did you say it was a possession charge?
That's what they've charged you with. Aggravated possession of drugs, a felony of 5th degree.
I was told I was arrested on paraphernalia.
Well, that is not what's before me at this point. So that's something that when your attorney reaches out to you, you may want to discuss with him. But that's what the charges are for you at this time. I don't know whether the charges are accurate or whether they're not accurate. That's not what's before the court today, but that's what has been charged by the state of Ohio. So once you're assessed, we'll have you back out shortly and after your attorney's spoken with you.
All right, thank you.
Mr. Stratton, if you want to go ahead and take the file, just let us know when you're ready and I'll get a call.
State of Ohio versus Stacy Tackett, case number CRB 22475. Your Honor, this is scheduled for here for review.
Ms. Tackett, can you hear me?
Yes, sir.
This is State of Ohio versus Stacy Tackett, CRB 22475. Ms. Tackett, it's alleged that you have failed to appear for a review hearing at some time in the past. Do we have a date for the review hearing that it was?
June 16th was when the one was called.
All right, Ms. Tackett, it's alleged that you have failed to appear for a review hearing scheduled June 16th, 2025 on your own case. Do you admit or deny that you failed to appear?
Yes, sir.
All right, so you're admitting that you failed to appear for that hearing?
Yes, sir.
Do you have a good reason that you didn't appear for the review hearing?
Not really, no.
Okay.
I need to go back to rehab, sir.
Okay, well, I was just getting ready to say we were going to test you because you don't look like you're in the best of shape right now.
No, I'm pretty sick, sir.
Okay. Well, would anybody like to assess Ms. Tackett? Any provider?
Mended Reeds might be able to, I'll have to call.
Okay. If Mended Reeds can't, can you facilitate getting someone to assess her? All right, thank you. All right, Ms. Tackett, we're gonna have a representative from a treatment provider reach out to you at the jail, and then once you've been assessed, we're gonna call you back out and see about getting you in treatment. Okay?
Okay. Do you know when I'll get shipped out?
I don't we're gonna have you back out here, you may not even get shipped out. We're gonna have you back out today.
Okay,
All right, thank you. We'll have you back out shortly.
okay.
State of Ohio versus Matthew Unger, case number CRB 21904, and Kiefer Wilson is on deck.
All right, this is State of Ohio versus Matthew Unger, CRB 21904. And it looks like back on October 25th of 2024, there was a bench warrant issued for Mr. Unger for leaving treatment without permission. Mr. Unger, do you admit or deny that you left treatment without permission?
Yeah, I touched treatment, but I thought, when I left trial, I was time to serve, so I wasn't aware I had any more time in the shell, so I thought I could leave treatment.
Well,
They said time to serve, but I left trial last time, so.
well, it looks like here you were sentenced on a theft charge to 30 hours of community service, and you have $405 worth of fines, court costs, and restitution.
Oh.
And then it also looks like there was a probation violation that was filed based upon this as well, for you leaving treatment without permission.
Yeah, when I left treatment though, for the charge that I had, it was time served. And I figured if I had anything else, it would be to hold me accountable. You know what I mean? Just to look out for me. Well, I was time served. I didn't think I had any more time on the show.
Well, you thought wrong.
Right, that's what I apologize.
So you were ordered the treatment and you left, so.
I thought, when I was in Columbus, I was in treatment. I've been clean 169 days.
Okay, so here's what I'm going to do then. I don't have any record of that at this point before me. So what I'm going to do is I'm going to have you assessed, and I'm going to have a urine screen done on you. And if
I'll be clean.
And if you're clean and the person assessing you comes back and says, hey, you know, that's not the case, we'll still have you, we're going to have you back out either way, and we'll figure out a way to resolve this today, okay?
Yeah, I've been clean for 168 days.
All right.
169 days.
Okay, so what I'm going to do is I'm going to have you screened, and then we're going to have you assessed. Is there anybody? All right, Mr. McCann's from RRS is going to call down. There's kind of a backlog, so it may take a bit for him to get through, but he's going to call down, assess you, and then we're going to see what your screen shows, and then we'll have you back out.
All right, thank you, sir.
All right, thank you.
State of Ohio versus Kiefer Wilson, case number CRB 25416, AD&C, and CRB 25162. Tessa Stapley is on deck.
Mr. Wilson, you have a letter from OVP where you failed to do what you needed to do at OVP, and RS has assessed him, and they have a bed for him today. Right?
All right. Mr. Wilson, can you hear me? All right, can you hear me?
Yes, sir.
All right. This is State of Ohio versus Kiefer Wilson, CRB 25416, A, B, and C. And this matter was set as a pretrial. And where was he treating prior to?
Prior, he was supposed to go to OVP. I don't even think that happened. And then he ended up back in jail. So we just asked that this be reset, allow him to go to RRS and see how that works.
Do we have any ankle monitors available?
I'm not sure. I believe we had one at the end of the day on Monday, but I'm not positive. I can call and check.
Your Honor,
Mr. Hill.
I don't know which cases are before the court right now, but he has other cases like this with Ms. Badgett as the victim already pending.
Okay.
And that's, they're set for August 1st.
This isn't a new arraignment. These are pending for pretrial.
I understand. This is 25 CRB
Okay.
We didn't want to call it together, Mr. President.
Okay. Yeah, we're calling, one was set for August, so we're calling them the same.
Okay, well, so here's the thing. We started out in March and April with him in treatment with the idea that Ms. Badgett was she has a civil protection order, and she was actually going to go to common pleas court and get that try to get the civil protection order dismissed. We were in favor of him going to counseling, and then this has now happened, a new set of charges, also involving domestic violence with Ms. Badgett as the victim.
I haven't seen you, oh, okay, the ones that are here on pretrial now.
25416A
Okay.
and B and C.
Okay.
Those, but there's also pending 25 CRB 162 that was already pending.
I just wanted to make sure we had all of the charges.
So from our perspective, this is not just put him back in treatment, we'll get back on track again. He's gone on and committed, allegedly, acts similar to what he did before. So we're not in favor of him going to treatment at this point.
All right.
Maybe once something is resolved regarding the charges
Your Honor,
themselves.
we'll just need to reset it then. I don't have, my schedule is tight today, don't have time to resolve these cases in that manner today. Maybe the prosecutor would have said that earlier. We would have worked on that to get that resolved. So the discussion earlier was treatment, and now we're out here and the prosecutor's discussing a whole different situation. So that's kind of aggravating on defense counsel's position that when we were back in conference room, we were discussing treatment and everything, and then we get out here, it's completely different. At the end of the day, when I have a pretrial scheduled, that we haven't addressed this issue prior to this. Okay, that's aggravating. We had him go out there and he got assessed. We were setting this all up because this is what we had discussed. I don't know, prosecutor come out here, change his mind, happens often, so.
And we're also
Okay,
raising
so
QRT.
I've not granted
charges
a
because
bond
we knew
either
that
way
we
at
have a
this
domestic
point,
violence.
so. Mr.
Okay.
Stratton,
That was one of the reasons why
is
they
there an
charged us.
argument that you want to make
Because
towards
he has
towards
domestic
bond?
violence charges.
Your Honor, this is what we had talked about doing. This is what we had talked about doing back there, that he was going to go to treatment. So we had talked about getting him assessed, which we went ahead and did to save the court's time and the time of everybody in the court so we can get this done. All right? I thought it was more of a formality that we come out here, we're going to set for another date, deal with the issues later that date, see how he does in treatment. And now we step out here and the prosecutor has a completely different story. I mean, I hope the court understands defense counsel's frustration with that.
And I can express my frustration back, but I would prefer not to. I think that it speaks for itself. But the reason, there are times in which we are rushing to get through the cases, talk about the cases prior to coming into court. And when Mr. Stratton says, okay, Kiefer Wilson, we're going to talk about treatment, he's going to go to a treatment, okay, let's move on to the next one. I don't even sometimes look at my notes at that time.
Well, let's
so
do this.
It's my fault.
Mr. Field, what are you asking for?
I'm asking for a bond of $25,000 cash or surety, come back on August 1st, address the issue of that will give Mr. Stratton and Mr. Wilson time to discuss how they want to proceed with these charges, if they want to try to resolve things on that day. We're going to require a plea or a trial on these.
Okay.
And then we'll talk about treatment.
Okay, Mr. Stratton, I presume your argument is what you just said for treatment.
It is. It is. There's no reason why we couldn't put him in treatment. If he leaves treatment, there'll be a warrant issued. I don't think there's any reason for him to set in there. Treatment is one of the things that his family is really believes that he needs. So, and he's fine with it. He's already got assessed. He's assessed for treatment. I think we should send him out to treatment. And I don't know if we have an ankle monitor. If the court wants to go that direction, we can go that direction.
That, I think, is more what I'm inclined to do, is not do exactly what either one of you are asking.
Okay.
I'm inclined to let him go to treatment, but I'm going to put him on an ankle monitor, a lockdown ankle monitor, so that he can't leave. Mr. Wilson, can you hear me?
Yes, sir.
All right, so I'm inclined to give you an opportunity against what the state's requesting. You're not going to be able to be released until there's an ankle monitor available. That may be today, it may not be today. But once there's an ankle monitor available, you'll be released only to treatment. And I'm going to give you some warnings at this point. So first off, there's been some alleged, and I don't know the facts of the case, so I'm not prejudging it, but there's been allegations that there's a protection order and you violated it. There's been allegations of domestic violence here against Ms. Badgett, who's here in the courtroom. If you were to somehow leave treatment and you were to somehow contact Ms. Badgett, I can promise you, you're not getting out of jail again. Do you understand that? Yes, sir. All right. Additionally, if you have a monitor on you and you cut that monitor to leave treatment, I want to make you aware that our common pleas court, you will be charged with some type of third-degree felony, and their position is you're going to go to prison for 3 years if you cut the monitor. Do you understand that? Yes, sir. So I don't want there to be any chance that you're not sure about what you can or can't do. Do you understand that? Yes, sir. And that's not just you leaving treatment, that's you attempting to contact Ms. Badgett. You attempting to have other people contact Ms. Badgett. Can't contact her kids either. At this point, I'm gonna say right now until this is resolved, unless there's something that is filed in the common pleas court that says otherwise, through a custody case, you're to have no contact. That's what the protection order says, I believe. So no contact directly, indirectly on your behalf, on social media. I don't want there to be any question. Do you understand that? Yes, sir. Okay. So I'm going to do a bond amendment that is going to be a $5,000 cash surety bond. It's going to be coupled with a GPS monitoring on 24-hour GPS monitoring on lockdown, and he's to only be released to inpatient treatment at RRS. Excuse me. Over 5%, no oil bond. And
Your Honor, come back on next Friday.
let's see, next Friday is 25th. We can probably squeeze one more in here. So I'm going to set this for July 25th on all cases for pretrial at 10 a.m. just to make sure that Mr. Wilson makes it out of jail and makes it into treatment. So, Mr. Wilson, that's going to be the court's order. Great. Thank you.
State of Ohio versus Tessa Stapley, case number CRA 25425, CRB 25426. Jason Harrell is on deck.
This is the State of Ohio versus Tessa Stapley, CRA 25425, CRB 25426. It's Mr. Stratton's case, and we're waiting on Mr. Stapley to be hooked up so that we can hear. Ms. Stapley, can you hear us?
Yes.
All right, my understanding is that Mr. Stratton's had his recall after the assessment.
Your Honor, she would rather go home than go to inpatient treatment. I think it might be,
I'm already,
you already what? Go ahead.
oh, I just said, okay.
Well, Ms. Stapley, we're presently really kind of out of what you want at this point. Got the charge in front of me. So, Mr. Heald, she's indicated at this time she's not interested in treatment. So, is there a bond recommendation?
We've asked for a $5,000 cash surety bond.
Mr. Stratton?
Your Honor, this is a low-level felony. I read some of the allegations, and I think you filed back to court. And I think there's some questions in those allegations. I asked that she be allowed to sign her own bond.
All right. I'm going to set bond on this at 2,500 cash assuring. And we will set this back, it was a felony, so
Monday?
let's do, are you here next Friday by chance?
I am.
Well, both of the dockets are terrible, but next Friday's a little bit better, so the July 18th for a preliminary hearing.
That's today.
Oh, excuse me, July 25th for preliminary hearing at 10 a.m. All right, Ms. Stapley, if you make bond in this matter, it'll be incumbent to you to be back here July 18th, or excuse me, July 25th at 10 a.m. for your preliminary hearing.
So how much is my bond?
It's 2,500 cash assured.
Is that the 10%?
That's up to the bondsman, whatever the bondsman charges.
Okay.
So if the bondsman charges 10%, that's what it is. If he charges 15%, that's what it is. Charges.
All right, thank you.
All right, thank you.
Thank you, Your Honor.
Thank you.
State of Ohio versus Jason Harrell, case number CRA 25-427, CRB 25-428 A and B, CRB 25-429 A, B, and C.
Before we go farther down the track, Mr. Stratton, I know you had something this afternoon. What time is it?
1:15.
Okay. After this case, are the rest of your cases that are involved?
Oh, I just have Ivy James, who you were testing in.
We don't have a result yet.
Okay. In the event that, Mr. Smith, if Mr. Stratton needs to go, because we've got another hearing, would you be okay with standing up with Ms. James?
Oh, sure.
Okay.
There's not a
Be
co-defendant.
excused, Your Honor.
There's not a co-defendant, right?
There's not a code.
I can stand up, yeah.
I think she's going to test.
I should, okay.
All right, this is, thank you, Mr. Stratton. This is State of Ohio versus Jason Harrell, CRA 25-427, CRB 25-428 A and B, CRB 25-429 A, B, and C. It's Mr. Smith's case, and we're having this matter recalled after Mr. Harrell has been assessed.
He has been assessed, Your Honor.
Yes, we are willing to accept him into our program.
All right, Mr. Harrell, are you willing to go into treatment?
Yes, Your Honor.
All right. Now, based upon the allegations in this, I have some concerns about whether or not you'll stay.
I don't know where. I ain't been in any trouble before.
Okay, well, I did see that I didn't see any other old charges or anything here from the court, and
I've never been in trouble, I'm almost 50 years old.
okay. Mr. Hill, any objection to an OR bond to release the treatment?
Some theft charges. Was the idea of a GPS monitor mentioned?
I don't know that we have one at this point, but I don't think that, I've not seen anything that would indicate Mr. Harrell has any other type of record or.
I don't know.
It's fine.
All right. All right, so Mr. Harrell, what I'm going to do is I'm going to set bond at 2,500 OR and order that you only be released to treatment and service provider you.
The counseling center in Portsmouth.
I thought it was counseling center, I just didn't want to say the wrong thing.
That's okay.
And so we're going to have you released to the custody of the counseling center for inpatient treatment.
Thank you.
Thank you.
Thank you, Your Honor.
Any day,
They come to get me right away?
As soon as they can do it.
any day but the 18th in August, Judge.
All right, so since you're going to be getting out, I want to get you some time in here. Let's do August 15th.
That's fine.
And that'll be for pretrial preliminary hearing. I'm assuming, Mr. Smith, you'll wait for time to...
Yeah, absolutely. We'll wait time since he's getting out.
All right.
Thank you.
I appreciate it.
All right, Mr. Harrell, make sure you go and do your treatment, and that'll probably go a long way to helping you through this case.
Hey, Your Honor, whenever you see me next day, I'll know first.
Okay, I certainly hope so.
I will, Your Honor. I'll know, man.
All right, thank you, Mr.
Yes,
Harrell.
sir, thank you.
Your Honor, we have several more recalls at the jail, but we're not ready to do any of those as yet because of your screens assessments. So we can proceed here.
Yeah, let's proceed here for now then.
State of Ohio versus Brian Bryant, case number TRD 251770 and CRB 25436A and B. Brian Bryant is set for arraignment today.
All right, this is case number CRB 25436A and B, State of Ohio versus Brian Bryant.
All of you is here.
Is that Mr. Steiner's case?
What's the arraignment? This is arraignment.
Oh, arraignment. What's that one?
All right, well, time is now 12:35 p.m. Mr. Bryant is not here for the time of his arraignment, so there'll be a KPS issue of trial.
State of Ohio versus Malachi Leland McComas, case number CRB 25417.
The State of Ohio versus Malachi McComas, CRB 25417. All right, Mr. McComas, it's alleged, well, first, it's alleged that on or about July 11th, 2025, you failed to appear for your arraignment.
Yeah, I didn't have a ride up here, and I've called every day to try to get it rescheduled, and I got a hold of somebody today, and they said to make it in here before court ends.
Okay. All right, Mr. McComas, did you hear my explanation of your rights before the court and the like earlier?
Yes, sir.
All right. So, Mr. McComas, it's alleged on or about July 5th, 2025, in Perry Township, you knowingly made or possessed an instrument whose customary or primary purpose is for the administration of a dangerous drug. To wit, one used hypodermic needle. It's an alleged violation of the Ohio Revised Code 2925-12A. Possession of drug use instruments, that's a misdemeanor of the second degree.
Yes, sir.
Misdemeanors of the second degree carry a maximum penalty up to 90 days in jail and up to a $500 fine. How do you wish to plea?
I plead guilty, but I also have cards here where I'm part of the syringe program.
If you want to show those to Mr. Keel.
From Greenup County.
Well, Mr. McComas has entered a guilty plea.
I've never even thought of this idea before. He has the right, I guess, to have possession of this in Greenup County, but not here. I assume he's in some sort of a program, he's being monitored or whatever. I don't know what to do. It's just the possession of a drug abuse instrument,
It was just a syringe.
and he entered a guilty plea.
He's entered a guilty plea. I've not entered a guilty finding at this point. I want to give him up first.
I would just defer to the court on it, honestly.
Okay. Well, Mr. McComas, that would certainly allow you to have it in Greenup County, but that doesn't necessarily allow you to have it here in Lawrence County.
All right.
So I will accept your guilty plea and I'm going to enter a guilty finding at this time. Where are you treating?
Where's this program? It's in Greenup,
What's it
Kentucky.
called?
It's the health department, Greenup County Health Department.
Okay, what's your treatment consist of?
It's just the syringe program. I will go there and pick up, they'll give me bags of syringes and clean needles and stuff, and then I'll take the old ones back. And
Are you receiving any type of counseling?
Yeah, there's counselors there.
Okay, I mean, how often are you receiving counseling?
Twice a week.
Twice a week?
Yes, sir. And I'm also part of methadone.
All right. Is there anything else you want to say before I sentence you?
No, sir.
All right, so here's how we're going to approach this. I'm going to sentence you to 10 days in jail, but I'll suspend them. There'll be a $100 fine. I'll order you to pay the court costs. There'll be 2 years probation. And as part of your probation, I'm going to order that you can, for now, that you continue your treatment at the Greenup County Health Department. However, part of your probation is going to be that you are to remain drug and alcohol free.
Okay.
So I'm going to order that you continue that treatment at the Greenup County Health Department, but I'm also going to order when you check in with your probation that you bring reports from your counselors showing what it is that you're doing and whether you're compliant with your treatment.
Okay.
That's going to be incumbent upon you to provide that.
Right.
Now, they may provide them and they may be willing to send them straight to the court, but I'm going to make that incumbent upon you to provide those things.
Okay.
And in the event that the probation doesn't get them, or in the event that there's other issues there, they can file a probation violation because they're going to be able to test you. You understand that?
Yes, sir.
Okay. I'm going to set you a review hearing date for January 23rd, 2026.
Sir, you can write that down in the form.
At 9 a.m. Before you leave, you're going to need to meet with probation.
Okay. So January 3rd?
23rd. January 23rd.
Okay. Is that all?
That's it. You'll need to meet with probation before you leave.
Okay.
Thank you.
State of Ohio versus Gary Calicote, case number TRC 25546 A and B.
The State of Ohio versus Gary Calicote, TRC 25546 A and B. This is Mr. Steyer's case set for pretrial.
I think we'll need Mr. Heald in the courtroom for this, so please have a moment. Thank you. Your Honor, this is a matter that it's an OBI with a breath test that is at .081, which, as you're aware, is within the margin of error for the test. For that reason, the state has agreed to allow Mr. Calicote to plead guilty to the failure to control with a fine and court costs at the court's discretion. And I believe the state is going to move to dismiss the OBI. I further prepared an ALS form to terminate the suspension that was commenced with the ticket.
Okay. Mr. Hill?
That's correct, Your Honor.
All right. So the A case will be nollied at state's request, and the B case, the failure to control, it'll be a $50 fine, and I'll order you to pay the court costs.
It might take a few days for this to get through the system, so I'd still be kind of careful driving until about 4 or 5 days, and then you're good. You got $50 in costs.
All right.
Okay.
Yeah.
Thank you.
Greatly appreciate it.
Thank you. May I approach with the form?
You may. I'll set a review hearing for January 23rd, 2026 at 9 a.m.
If you don't get it, January 26th.
Can you pay the fines and court costs today?
Not today. I'll probably be able to Monday.
All right, so here's what I'll do. I'm going to put you on 2 years of non-reporting probation, but note that once you've paid your fines and court costs, you'll be terminated from probation.
All right, thank you.
So you'll need to talk to Mr. Major before you leave.
Yeah, I was going to say, I was actually in Texas. I caught a helicopter right there.
Oh, gosh.
I was down there with the fire restoration and rescue efforts. Thank you.
Step out there, come talk to you in a minute.
State of Ohio versus Joe Bowles II, case number CRB 24744, CRA 25412.
This is State of Ohio versus Joe Bowles II, CRB 24744, CRA 25412, matter 7 pretrial. All right, it's a good report, Mr. Bowles.
Thank you, sir.
Mr. Guild, any input on this?
No, Your Honor.
All right. Well, I'm gonna let you continue on in treatment. Keep doing what you're doing. Looks like this was previously set for September 5th, 2025 for a pretrial. And then have a new date for today. So was there a reason the September 5th didn't work?
Yes, I had a holder out of Pike County,
Okay.
and they did come get me, and I went up there and handled that.
Okay. Does the September 5th date work now?
Yes, yes, Your Honor.
I'll set it for another pretrial September 5th, 10 a.m.
And could I address you about the lady we had assessed?
You may, yeah.
She's good to go. We just wouldn't be able to take her until Monday unless you guys really need it, and then it'd probably have to be by 2 or 3 so we could assess her and stuff today.
Okay.
But yeah, Monday she's a good to go.
You would call the name?
Stacy Atkins.
Stacy Tackett?
Tackett, yes.
Okay.
Your Honor, is Mr. Bowles, is the rule more than completed? So he,
Oh, I didn't see the
if that's
before.
what he was saying, he turned himself into Pike County on that. Okay.
This is CRA 25412, it was a Rule 4 matter. Looks like they did clearly come get Rule 4 will be dismissed.
Thank you.
State of Ohio versus James Gray, case number CRA 25265 A and D, CRB 25266.
All right, this is State of Ohio versus James Gray, CRA 25265 A and D, CRB 25266. This is set for preliminary and pretrial.
Your Honor, it's our intention to, I don't know if Mr. Gray put up a bond. If he put up a bond, he may want to waive his right to a preliminary hearing.
Okay.
Or otherwise, we would nolly it to the grand jury.
Okay. Mr. Gray, here's what the state is looking at doing on this at this point. So they're indicating that they're going to take this to the grand jury as a felony. They have every right to do that. There's 2 ways that can happen. So the first is you have the right to have a preliminary hearing here today. However, they have a right to not go forward with that if they wish. So if you demand your preliminary hearing today, Mr. Healy's indicated he's going to dismiss the case, which sounds great, but if he dismisses it and then they take it to the grand jury, which he said his intention is, then if there is an indictment, there will likely be, it'll be filed in common police court, there'll be a new warrant issued, and then they'll come and arrest you, because once the case is dismissed here, your bond would be gone. Do you feel like you understand that?
Wait, go over that last part again.
Okay, so if they dismiss it here,
Okay.
and take it to the grand jury, if it's dismissed, then when they dismiss it here, your bond that you've posted gets dismissed with it. So if there's an indictment and it's filed in common police court, you'll likely get another warrant and they'll come arrest you and you won't have a bond.
I won't have a bond?
If they dismiss it. You also...
I'm confused.
It's okay. So Your preliminary hearing, you can either, Mr. Hill has indicated that you can either waive your right to preliminary hearing today, or if you say, no, I'm not going to waive it, he's going to dismiss the case. Now, if he dismisses it, your bond is then going to be gone.
Okay, got that part.
Does that make sense?
That makes sense.
All right, so if he dismisses it, your bond is gone. Either way, Mr. Hill has said he's taking it to the grand jury.
All right, got that part.
So if it goes to the grand jury and you don't have a bond, and there's an indictment, then at that point, there's probably going to be a warrant, and you'll get arrested, you won't have a bond at that point until you get to court there. If you wish to waive your right to preliminary hearing today, your bond will stay in effect.
Okay,
And then they'll send you a letter to come show up to common police court, and you'll still have a bond.
okay.
Does that make sense?
Yeah, that makes sense.
Okay. So the question I would have for you is, do you wish to waive your preliminary hearing, or do you wish to say, no, I want my preliminary hearing, and then Mr. Hill's going to dismiss it and dismiss your bond?
I wish my lawyer was here. I hired an attorney. We hadn't met. He went on vacation, and he had a car accident while he was on vacation. He isn't back yet.
Okay. Who's your attorney that you hired?
It's a guy, Al Jackson.
Okay.
So I'm not understand. I'm just having a hard time figuring this out. So if I waive the hearing, right? All right. Then they will. What happens then?
They're still going to take it to the grand jury.
That's fine. Okay, great.
But
I can't wait to get it in court, to be quite honest.
Sure, understand. So they'll still take it to the grand jury. The difference is if you waive it, you keep your bond.
Okay.
The difference is if you say, I'm not waiving it, if you want me to boil it down to its most simplistic way to look at it.
Yeah, please.
If you waive it, you keep your bond. If you don't waive it, if you say, no, I don't want to waive it, Mr. Hill's going to dismiss it and you lose your bond.
Okay, well, I'd rather keep my bond.
Okay, so you want to waive your right to preliminary hearing?
Yes, that's fine.
All right. So after having a colloquy with Mr. Gray, I'm going to find that he has knowingly and intelligently waived his right to preliminary hearing. There's a form coming out that's saying that for you to read through. It's indicating that you knowingly and intelligently wish to waive your right to preliminary hearing today. You have the right to have that. Like I said, however, Mr. Hill also has the right to dismiss that if you're not waiving it.
Okay.
And Your Honor, there's the misdemeanor too, which we will nolly to the grand jury.
All right, the misdemeanor will be nollied to the grand jury as well. So, Mr. Gray, this matter is going to be bound over to the Court of Common Pleas and grand jury for further consideration. You'll need, Mr. Hill, if you would, make sure that the state has an accurate address for Mr. Gray.
Yeah, they're not sending it to the right mailing address.
Okay, so we want to make sure that they've got the right address so that if there is an indictment.
Because I came in yesterday, because this is when I was supposed to be here, then it was changed to today. I didn't get a letter telling me that it changed to today.
Okay. So what's your address, Mr. Gray?
Same town, same zip, P.O. Box.
Just go ahead and recite the whole thing. Okay.
P.O. Box 963, Gallipolis, Ohio 45631.
Okay. So I wanted to make sure that they had since you don't have an attorney here today, I wanted to make sure that they had the correct address so that way if there is an indictment and they send it out, they'll have the correct address to send it to.
Can you give us an actual street address also?
You have the street address.
P.O. Box?
No, that's my mailing address.
I see. So we
The
already.
street address you have.
28 Birch Lane.
That's it. I don't get mail there.
All right. So that'll be, the order's going to be bound over for further consideration by the grand jury. So you won't have any further court hearings at this point, Mr. Gray, unless and until something comes up, and at that point, if you wish the attorney that you...
Oh, I've just got served with a civil action today, so I've got to get one that'll do both.
Okay, so your attorney may or may not want you to testify in the grand jury. That's something that you'll need to discuss with him, or if the state would even allow you to do that. And if so,
Sure.
I'm sure he'll be able to reach out to them and then
Sure.
have further conversation.
Sure.
All right, thank you, Mr. Gregg.
Thank you. So I just wait until I get something in the mail? Is that what I'm waiting for?
Yeah, presently, there is now nothing pending against you that is current until there will be an indictment.
All right, that's great. I'll get a lawyer and we'll get it all fixed up, because I've got witnesses to call and everything. Thank you very much.
All right, thank you.
We're through?
You're free to go.
Thank you.
State of Ohio versus Nicholas Atkins, case number CRA 24294, CRB 24295, CRB 24293.
We have Nicholas on video here, Your Honor.
Yeah, he was MVP, looks like he still is.
It's the State of Ohio versus Nicholas Atkins, CRB 24295, CRA 24294. It's Mr. Roger Smith's case set for a preliminary hearing.
Judge, I would defer to Bree at OVP and see how he's doing. He was, I think, at detox.
I received a report
Okay.
here, and it looks like his report is very good. I don't know if Ms. Mint has anything further that she wants to add to that.
No, Nicholas is doing well. He is going to complete the 30-day inpatient treatment here, and he's going to continue to long-term treatment in West Virginia, where he has West Medicaid.
Okay. Mr. Smith?
Well, I assume we'll come back when he's ready to graduate, and then we'll get him over to West Virginia. Do you know when that is? When is he expected to graduate, complete the inpatient record?
I believe it's July 31st.
Okay. I'm here the 1st, 4th, or 8th, or I could actually probably do, if you want to do it before, maybe the 28th. What
Let's
else?
do the 4th.
I'm here.
All right, let's do August 4th for preliminary hearing.
Oh, I see. Monday, July 28th.
And I'll know that it's expected graduation at that time. All right, the August 4th, 10 a.m. for preliminary hearing.
Okay, thank you, Your Honor.
All right, thank you, Mr. Mayor.
State of Ohio versus Stephen McGinnis, case number CRA 2420309, and CRB 24310, and TRC 24257.
No, I don't know.
Is there anything?
This is the State of Ohio versus Stephen McGinnis, CRA
You
24.
probably don't, I'm just gonna go follow it.
Dated 5, CRB 24810, TRC 24257, This is Mr. Smith's case, but I don't see Mr. McGinnis.
I don't need, Judge, I was asking the prosecutor if he's perhaps in treatment, because for whatever reason, I don't have his file with me. But if it was in my mind, there was...
He's at Shawnee.
Shawnee, yes. He was at a place in Grayson, but then Shawnee, he wound up transitioning to Shawnee last time we were here. Good report. I don't know what's happened.
I had him down, I had this down for the 21st, for Monday.
That might be why I don't have my file. I don't, it's on today's docket, but
The OBI is on for 7/21st, and the other two are on for 7/18, so there could be an error in.
Why don't we do this? Let's set all charges for the 21st.
okay, that would explain why I don't have a file for
And that
that.
could also be why he's not present.
Yeah, actually, I do have him on my docket for the 21st
Okay.
and today. Okay.
So we'll set them for July 21st at 10
Thank you,
a.m.
Judge.
on all matters.
And that concludes my case, but I have that one for Mr. Stratton, Ivy. I don't know if she's been assessed yet or not.
We're getting ready to recall.
Oh, perfect, okay.
State of Ohio versus Kelly Doss, here at court, case number CRB 25206, CRB 25207AB.
All right, this is State of Ohio versus Kelly Doss, CRB 25206, CRB 25207AB. This is Mr. Steyer's case.
Your Honor, following the issues Monday, Mr. Doss has transferred his treatment to Mended Reeds. He's gotten started there. I don't know if we have a report at this point. He's only been there for a day or two.
Tuesday, yes.
He is asking about the possibility of getting his monitor taken off of lockdown status and opened up 7 to 7.
Not yet.
Thank you.
We'll just go ahead and stop you there, not yet. with the problems that you just had in the other place, not willing to do that. You're gonna have to get some real good time in. You're doing great, I don't wanna see that interrupted, but we're gonna need you to get some good time in and good time doing the right thing before I reward you. I felt like I gave you a little bit of a benefit of the doubt, just letting you exchange treatment providers.
I thank you for that, Your Honor.
And, but I'm not willing to go as far as we're feeling like I'm rewarding your bad behavior at the other place by suddenly letting you change and opening your monitor up. So I think you need some more time before we do that.
So I don't know what sort of a time frame that we'd like to come back on. I would think maybe 2-3 weeks to give him time to get enough time into the program to have a meaningful report.
August 22nd,
I have a jury trial on the 22nd, Your Honor.
8:15.
Oh,
Sorry.
I was reading that as a time, not as a date. I am here the 15th.
All right.
Actually, we already, well, no, that's 18th. Actually, we already had it down on the 15th, on the 18th. We may have had that, we had the date of the 18th already set, but I don't care to change it to the 15th.
We can do the 18th.
Yeah, I think we had that day set and then the issue arose.
Okay, so let's do August 18th then for a preliminary hearing. Mr. Goss, keep doing well. Keep doing well. I don't want to see, I don't have to take you in the back or put you back in jail.
There you go. I'm not.
So whatever they ask of you, that's what you do. No questions, no.
I'm not. I really am.
If you want to do that, do it all, okay?
Yes, sir. I wanted to thank you again, and like, I've been completely compliant with them. Like the problem that I had at the other place, I stopped myself here because it was over a cell phone. I went ahead and turned my phones in when I got there. Even the one that they didn't know about, I went ahead and gave it to them because I'm not trying to mess this up again. I need the help. And I thank you very much.
You're very welcome.
Thank you, Your Honor.
State of Ohio versus Thomas W. Ward II, case number CRA 25121, CRB 25122, A and B, CRB 24719, CRA 24259.
Your Honor, I've looked around for Mr. Ward, haven't seen him, and haven't found that he checked in this morning.
All right,
Well, hang on, we have a,
Sorry. Is it Thomas Ward?
oh, is that the case? I didn't know that.
Mr. Ward was in services with us. Got all the way to transitional, was doing really well, and then just kind of out of the blue took off about 2 weeks ago. We have not been able to establish any type of contact with him since.
Mr. Major.
I believe Mr. Ward is in custody in West Virginia after a high-speed chase. That sucks.
Okay, well, I hate to hear that, but, so it's the State of Ohio versus Thomas Ward II, CRA 25121, CRA 25122, A and B, CRA 24719, CRA 24259. There'll be a bench warrant to issue immediately for failure to appear here today, and understanding that we'll see Mr. Ward at some point in the future once his matters may have been resolved to some way, shape, or form in West Virginia. Thank you.
Thank you, Your Honor.
State of Ohio versus Marshall Cullen, case number CRA 2590. Sentencing.
State of Ohio versus Marshall Cullen, CRA 2590, Mr. Cullen's present. And this was set as a second hearing. Mr. Heald, well, looks like he's done a substantial amount of community service. He did 54 hours of community service since the last hearing. You've only got 6 hours left, it looks like, unless you've done something in the last few
I
days.
asked you the last day that I came in if this was going to be my last day, and you said yes, this one was your last day, so I just wasn't informed about that last 6 hours.
Looks like May 29th.
He's done it since then.
Okay.
He can check the probation, we can tell him exactly what he has left.
Okay, because this one is, as of May 29th, you had 6 hours left, but you also have $795 of fines.
I just paid them yesterday online. I had the receipt, but I've been here so long, my phone has died.
Okay.
I do have
Did
the
you pay
receipts.
all of it?
I paid everything.
You did pay $795. online, that's probably not been updated.
All right, here's what I'm going to do then, based upon Mr. Cooper indicating that he believes you're finished there.
Your Honor, if you don't mind, I can take this folder and go check, and if he's finished, I can complete his case.
Rather, it does say on here that he was given 6 hours credit on July 12th.
Okay. So
At
now
Lawrence County Meeting Court, so he was, that would have.
that will take care of it. All right, your case is completed at this point then.
We're done?
You're done. You don't need to come
Sounds
back.
great. I appreciate it.
No problem. Thank you.
State of Ohio versus Diane Bailey at the Lawrence County Jail, case number CRA 25433.
Okay. While we're down here.
Diane Bailey at the Lawrence County Jail.
Well, and usually we still have a couple of people in the gallery back there. You guys here on a case?
We're waiting on Andrea Jones,
Okay.
Lawrence County.
Okay. I just wanted to make sure that we didn't miss a file or anything and you're just waiting for nothing. They're on. They're coming on.
They need to adjust it until it's up water.
I don't think they have that.
You know, it's anywhere in
No. All right, Miss Bailey, can you hear me? You're muted. Okay, Miss Bailey, can you hear me?
Yes.
Okay. Your background's a little distorted. I don't know if they can hear you get down there to adjust it.
I need to adjust it a little bit. Is it? What is it that needs adjusted?
Well, it's okay. We can, as long as you can hear me, we can proceed.
Okay.
All right, this is State of Ohio versus Diane Bailey, CRB 25433. Earlier, we were on record and Ms. Bailey entered a guilty plea and there was a guilty finding by the court. We had Ms. Bailey screened, and Ms. Bailey, you came back positive for a whole bunch of things.
Like what?
Amphetamines.
I'm prescribed amphetamines.
Okay, buprenorphine.
I'm prescribed that. I had a doctor's appointment today, as a matter of fact.
Okay, benzodiazepam.
Yeah, I'm prescribed all that stuff.
THC.
Yeah, I smoke weed. My son was just killed in a car wreck.
Okay. Well,
And my house.
but more importantly, do you have a prescription for meth?
Meth?
Mm-hmm.
I don't do meth.
Well, you tested positive for methamphetamine.
I don't, oh my gosh, I don't do meth.
So,
There's no way, I don't do meth. I do Adderall.
okay.
There might be something, hold on, I take Ativan. Okay, they prescribed me some different things when my son just died.
Okay.
I can't, I told you my doctor was, but I'm not on anything I should be.
Mr. Keel, any input? This is a M1 theft from Walmart.
She has some prescriptions, which means that she's attending to some needs that she has. I guess what we would, she's pled guilty previously. I guess we would want her to come back to the court for a review hearing and bring proof that she's doing whatever she's doing.
Okay.
We would
I think that
ask,
is a good way to handle this.
we would ask for a suspended jail sentence and give her credit for whatever she's been in there and whatever community service the court felt was appropriate, and whatever fine. I don't believe there was any restitution due to Walmart on this.
Okay. Why don't, instead of sentencing her today, let them come back for a sentencing, and that way, because I'm quite confident that the court will want to see what prescriptions that she has. So here's what I'm going to do, Ms. Bailey. I'm going to set you a bond, and it's going to be a $2,000 OR bond, which means you get to sign yourself out. Now, if you do not appear back to court and you're ordered to, you're going to get what's called a bond forfeiture and a warrant. And so what that means is when you get picked up on that warrant, you're going to have to pay the $2,000 owner recognizance bond before you even get a new bond.
Okay.
You understand that?
Yes.
So it would be, you don't pay anything if you show up to court when you're supposed to. So I'm going to set you a sentencing hearing.
Okay.
And it's going to be very quickly.
Okay.
I'm going to set it for Monday.
Okay.
And it's going to be incumbent upon you to bring proof of all of your prescriptions on Monday. Because that is going to make a big difference as to how this is treated by the court.
I had an appointment today, literally, to see my family doctor. For my Suboxone shot and all that.
Well, you'll need to either make an appointment or walk in. You'll need to bring copies of all your prescriptions.
So since today's Friday, we'll be able to get, or I could go to the pharmacy?
The pharmacy can likely give it to you as well.
The pharmacy? Okay.
All right. So we'll see you back at 10 a.m. on Monday.
Okay. 10 a.m. Monday?
It's July 21st.
Okay.
It'll be Monday, July 21st.
Okay.
See you back then.
Okay, thank you.
Thank you.
State of Ohio versus Ivy James, case number CRB 25-125.
Okay. All right, this is State of Ohio versus Ivy James, CRB 25-125. We had Miss James tested after Miss James had indicated she had been clean for some time. Mr. Smith, have you seen that?
I have not, Judge. I'm standing for Mr. Stratton. I don't know if he'd seen it either.
So she was probably positive for one substance, and it was buprenorphine, which
perhaps have a prescription.
I was going to ask Ms. James.
Yes, I got the Sublocade shot from amended release.
Okay, that would make sense then. All right, so let's set this back. Here's what I'm going to do, Ms. James. We'll recall the warrant. I'm going to, you came in 2 days ago, I believe. Is that?
3, but I've been arrested for 6.
Okay. You've been in Ohio for 3? Today's your third day in Ohio?
I've been in Ohio for 6.
Okay. Where were you arrested?
Cincinnati.
Okay. So, was it just on this?
Yeah.
All right. So here's what I'm going to do. On the failure to appear, I'm gonna sentence you to 6 days in jail, give you credit for all 6.
Okay.
I'm aware of that. You're gonna get credit for the 6 days that you were here, or that you were arrested on, between Cincinnati and our jail. You're gonna get, so I'll send you to 6, give you credit for 6. This is Mr. Stroud's case. Is there another day that we know that Mr. Stroud was here on? I know we had some trials coming.
All of the files are on. So
I
don't-
thought the 25th, he said he was here on something.
Okay.
If not, I will be, and I could stand up again, but I think he did say the 25th.
I think that was first.
Pretty sure, but if that's an issue, I'll be here to stand up again.
All right. Ms. James, I'm going to set this for another pretrial on August 25th at 10 a.m. And I'm going to, because even though you're clean now, what I want you to do between now and then is I want you to go get an alcohol and drug assessment. And I want you to bring the results with you when you come to that pretrial as a condition of your bond.
Okay, so,
If they say you don't need anything, then bring something saying that you don't need anything.
okay, so, when are they gonna let me out today then?
You're going to be released today whenever they can book you out.
Okay,
So your bond is continued from the case from where it was before. I've sentenced you on your failure to appear.
okay, thank you. Could I get, paperwork, please, on, the, let out today?
It's going to be sent. It's going to be sent. It's going to be sent down to the jail today.
Okay, thank you.
All right,
We're gonna
thank
ask, we're gonna need a time waiver.
Okay.
She's getting out, so that's fine, Judge.
All right.
No, she's out of jail.
I'll find that time has been waived by the defendant.
Okay, thank you.
All right, thank you.
August 25th, that's for sure. She didn't show up for trial. She left.
State of Ohio versus Ashley Dinoff and Andrea Jones will be on deck.
All right, this is State of Ohio versus Ashley Donna, CRB 23-736, CRA 23-725. This was, I believe, Mr. Steyer's case. Mr. Smith, would you care to stand in?
Here I come.
I know we've asked a lot of you today, but would you care to stand in on another one?
Be fine by me.
All right.
I can take her today.
Okay.
I think she ran on me once before.
Okay.
I'm sorry, Miss Taylor.
I mean, I'll stick her out in the woods, that's all I can do.
Your Honor, we've got a theft charge from Walmart that's been pending since 2023. So we would want a cash or surety bond and come back for a pretrial on it unless she's willing to plead guilty on that today. I mean, this has been going on for 2 years.
Not my client, Judge. As long as she wants to do it on her own, I don't know, that would be
Sure,
fine.
she's indicated she'll enter.
Oh, then we're good, we're good.
All right, so, ma'am, you're making a complete admission that you committed the theft charge from in 2023, is that correct?
Yes, sir.
All right, so I'll accept your guilty plea and a guilty finding. We're not going to do a sentencing today because we're going to let you go treat. But we're going to come back on another day for sentencing to see how you do in treatment. So, were ankle monitors available or not? I know you probably one, but
I don't believe there is.
okay. So with this being a first degree misdemeanor, I'm going to give you an opportunity, ma'am. I'm not going to put an ankle monitor on you.
I promise, I want to get better, like, I want to be better for my kid, you know, this shit's been going on too long with me.
I understand. So I'm going to give you the benefit of the doubt on that today. If for some reason you leave treatment again, without permission, you're probably going to be laying it out in jail. Do you understand?
I do.
Okay, because you haven't been sentenced yet, and there's up to 180 days you can be sentenced to in jail at this point.
Your Honor, she also has the possession charge, felony possession charge, I believe.
That is correct as well. So actually, there's up to a year and a half that you could be sentenced to. So
I just want to get better, you know?
you've got a lot of incentive to complete your treatment.
I will.
All right, so I will keep the bond at 5,000 OR at this point and order that she only be released to Bethesda for treatment.
We'll be there to get her today.
Thank you, Judge.
All right,
Thank
we're
you,
going to be
Your
there to get you today.
What date should I tell Mr. Steyer
All
we're?
right, so we're going to set another hearing for her August 29th.
Thank you, Your Honor.
I'll let Mr. Steyer know, Judge.
And that'll be a sentencing hearing.
Yeah.
State of Ohio versus Andrea Jones, CRB 25439.
6 o'clock on YouTube.
All right, this is State of Ohio versus Andrea Jones, CRB 25439. Ms. Jones previously had entered no contest plea and was guilty of finding, and we had her assessed by hometown recovery.
Yes, I did speak with her. She qualifies for inpatient services with us, and we could pick her up today.
Okay. Ms. Jones, you heard the results of your assessment. Are you willing to go into treatment today with hometown?
Yeah, I guess.
Well, that doesn't sound like the best attitude in the world.
I mean, do I have a choice?
Well, you certainly have a choice. If you don't go into treatment, I can sentence you to 30 days in jail.
No, I don't want to stay here in jail. I'd rather go to treatment.
Okay, so here's what I'm going to do. I'm going to delay sentencing on this matter. I'm going to set you a bond at 2,000 OR. Release only to hometown recovery for inpatient treatment. And we're going to come back we're going to let you get in, get situated. And we'll have you back. I don't want to go too far out, we'll just have you back August 4th. At 10 a.m. for sentencing.
All right, thank you, Your Honor.
Thank you.
Oh, your print notes, okay. It's like your print notes. Mine too.
State of Ohio versus Stacy Tackett, CRB 22475.
Oh, it's getting smaller about the files you need to talk to me.
That's true.
All right, this is State of Ohio versus Stacy Tackett, CRB 22475. And Ms. Tackett has indicated that she wanted some treatment. And did you ever get assessed?
Yeah.
Do you know who it was that assessed you?
Somebody from Minden Reed,
Okay.
Amy, I think.
That was Amy from Minden Reed.
Did anybody ever get a degree?
Well, Well, we're gonna need to recall you here in a few minutes, unfortunately. Because the representative from Mended Reeds has just left, and so we're gonna try to get a hold of her.
Okay, what I was wondering is, I was at Bethesda. What would be go back to Bethesda.
Your Honor, if I may, I do believe that Mended Reeds asked about her earlier on a different case and said it'd be Monday before they could take her.
Okay. She's asked to go back to Bethesda if someone wants to call.
Who is it?
This is Stacy Hackett.
And I can take her.
You can take her?
Please.
Okay. She asked for treatment, so this wasn't even this is our own case.
She ran on me before.
Yeah, I'm so sorry.
You gonna stay put?
Yes, I promise.
All right, Ms. Hackett, I'm gonna give you a shot. So
Okay.
here's what I'm gonna do. I'm gonna recall the warrant. I'm gonna set you a bond. A 2,000 OR bond release only to Mended Reeds Bethesda for inpatient treatment.
Okay.
Now, you gotta stay put there. You understand?
I will. I promise.
If you don't, you're gonna get another warrant, and then you're probably gonna end up laying your time out in jail. Do you understand that?
I understand.
And I know that jail is not a pleasant place to be,
No.
especially when you're sick. All right,
Would you be able to come get me today?
I'll be there today.
she'll be there today.
Thank you so much.
All right, that'll be the order of the court at this point. We're gonna set you a new date to be back. I'm gonna set you August 4th, because I don't wanna go too far. Because I wanna make sure you get there and you stay.
Okay.
So it's pretrial review, Your Honor.
We'll set it as let's set it as a pretrial. It'll be a pretrial on review.
Thank you, Your Honor.
All right, thank you. Be 10 a.m. See you back then.
The State of Ohio versus Matthew Unger, CRB 21904.
Hello.
All right, this is State of Ohio versus Matthew Unger, CRB 21904. Mr. Unger's present via Zoom. We've got the results of his screen, and you were only positive for buprenorphine, which should be some form of Suboxone or Sublocade. Are you prescribed?
I've been off the shop for a long time, and I don't understand how to be on there, but
Your Honor, I'm sorry, I have that case number again.
Yes, it's CRB 21904. All right, and was there an assessment done on him?
Yes, we have agreed to take him, but Monday would be better if we could pick him up.
Okay. What is your recommendation as far as treatment goes?
Since he's been clean for that many days, we would recommend to put him in a 2.1 level care, like a sober living, so he would come to us and he will be able to work around this area.
Okay.
And still get the group and the counseling,
All
mental
right,
health.
Mr. Unger, you've heard what the assessment was. I typically go with whatever the assessment says on those things. Are you willing to go into their sober living facility?
Yes.
All right. So I'll set you a bond. They're not going to be able to pick you up till Monday, but I'll set you a bond. It'll be a 5,000 OR bond, and it'll be released to RRS only for treatment as they see fit. And I'm going to set you a hearing for August 22nd.
all right.
Be 10 a.m.
All right, thank you. So Monday then?
Yeah, they're going to come get you on Monday.
All right, thank you, sir.
Thank you. It'll be a pre-trial on review.
Thank you, Your Honor.
All right, we're going to recall down to jail if you're listening. We're going to recall Andrea Jones. Understood, not a problem. You approach.
You can see why I need a stamp. You can see why I need a stamp. Oh, I love one of those.
All right, this is case number CRB 25-439, State of Ohio versus Andrea Jones. Ms. Jones is present via Zoom where we had this matter recalled. Ms. Jones, can you hear me?
Yes, sir.
All right. Ms. Jones, we had previously set a bond. Hang on one moment. We had previously set a bond in this matter for you, and scheduled you back for sentencing, allowing you to be released to hometown for inpatient treatment. The court has been given a little more information from both your provider and potentially some family members that they don't believe you're going to stay put. So I'm going to go ahead and modify that bond, and I'm going to add an ankle monitor component to that. So you'll be released once there's an ankle monitor available to the treatment provider, and so you're going to have to stay put. Now, that being said, there's some things that you need to be aware of. So first, if you cut that monitor off, you will end up charged with up to a felony that will have carry up to 3 years in prison on it. And our common pleas court has taken the position that if you cut the monitor and run, they will give you every day of that 3 years. Do you understand?
Yes, sir.
So if you do, if nothing else, the one thing I will tell you is do not cut our monitor. Do you understand that?
Yes, sir.
All right, so we're going to amend the bond again to add an ankle monitor component to make sure you stay put. We're still going to schedule the sentencing for August 4th at that point, and we'll come back and we'll review everything at that time.
All right.
All right, so that'll be the deal with the court.
Thank you, Your Honor.
Thank you. Thank you. All right.
I believe that's all we have.
Okay, you guys are good to go. That's all we have here. The court is now adjourned.
But he says, I'll have him come in and sign a statement.
No, sir. Court's adjourned now. You too. Thank you. Mr. McKeon, thank you.
Okay, well, I have to do. We're gonna have to go to Arraignments and ask him to get that guy, so we can get him to give a statement. Otherwise, it's gonna be hard to prove the case.
So have Carmene's get that guy, give him a second.
Or to find out what his name is, so we can get a deputy to give his statement. Or tell him to give a statement or something.